Okay, it's 10 a.m., so we're going to get going. Representative Quayle, would you like to lead us in the pledge? Okay. We're going to open up the public hearing for the House Election Law Committee. Just a quick kind of advice to the committee members. Today is going to be the first day of what I call the session of grind. So if we were to only meet on Tuesdays from now on, we would have to hear over 18 bills every Tuesday. So a couple things. There's going to be 1 or 2 days we're going to have to come in not on a Tuesday. And number two is what you're going to see today, where we're moving people along, we're moving bills along quickly. That is going to be our normal. There's just no other way to do it. So I understand the concerns against that. We have 75 bills in our possession currently. There could be more coming through vacation, not through vacation, but people vacating bills. So just be aware. I understand that not everybody's going to like when I'm imposing the time limits and moving people along. You got to talk to your colleagues about not filing 75 bills. And then we can go back to the way it was. But this is what it's going to be like. So we're going to have probably some growing pains today as we move through 11 bills, which is, by the way, not enough. But that's how it's going to be. So anyways, we're going to start it off. Going to open up the public hearing for House Bill 107 relative to political advertising printed in newspapers, periodicals, or billboards. Representative Perez is recognized for introduction of the bill.
Thank you. Thanks for hearing my bill. This is just a cleanup. I'll be 2 minutes. Actually, this is to add what was taken out of a bill last year. And what it is that the political advertised printed in newspapers, periodicals, billboards don't need to be marked at the beginning and at the end. It really shouldn't be the responsibility of outlets to be responsible for what candidates are putting on. And this came up, for those of you who were not here last year, came up because there was a court case against a small business, a small paper owner in Londonderry, and because she didn't write political advertisement above some political advertisements. I mean, if it said Christine Perez for, state rep, obviously it was, but she was taken to court and she was fined for it. So, and I'm willing to take questions.
Are there questions from the committee? That's easy.
And I feel your pain. We had 65 people speak at a hearing yesterday.
I hear you. Okay, thank you, Representative Perez. I think I only have one pink card. So I've got, it's the name I'm going to butcher. Kaylee, you don't, I'm going to try. Estratio. Yes.
Of the House Election Law Committee. For the record, my name is Kaylee Estratio. I am a Durham voter and public policy fellow with Open Democracy. We're a nonpartisan nonprofit representing 36,000 voters across the state. And I'm submitting testimony today in opposition to HB 107 relative to political advertising printed in newspapers, periodicals, and billboards. The existing statute RSA 66416, which requires political advertisements to be labeled as such in print, is rooted in common sense. HB 107 would effectively delete this language from current election law, allowing for the unintentional perpetuation of political misinformation. Electoral transparency is an integral component of a healthy democracy, and I see no reason to backslide by withholding potentially influential information from voters. Voters should have the right to know who is buying influence through ads. The primary goal of political advertising is not to inform the public in a neutral manner, but to gain more votes. And naturally, this can lead to the unfortunate inclusion of hyperbolic language and falsehoods in otherwise well-intentioned advertisements. And there is no federal or state penalty on the books for lying in paid political advertisement as of now, which is why holding candidates and committees accountable through mandatory disclosure is so important. Clear precedent has also been set regarding the matter. Miss Deborah Paul, as mentioned before, publisher of the Londonderry Times, was found guilty of 5 misdemeanor charges and fined in 2023 for failing to mark political advertisements as such, despite receiving several warnings in the years leading up to this. The consequences for omitting this crucial information are clear and should not be dismissed on a whim. Please consider voting HB 107 expedient to legislate. Striking this legislation would be detrimental to the integrity of our campaign processes and the already fragile system of media messaging that our society relies so heavily on. Thank you.
And will you be taking questions?
Yes.
Are there questions from the committee? Okay. Oh, yes, Representative C.
Thank you for, Mr. Chairman, thank you for taking my question. Shouldn't it be, the onus be on the person buying the ad rather than the publisher?
I would say that the media has a duty to just disclose any information that they have.
Further questions? Seeing none, thank you. I don't have any more pink cards. Representative Gazowski. Nailed it. Can you grab me that blue sheet? Online, we had 3 in support, 24 opposed, 0 neutral. And signing up in person and not speaking was 1 against. So with that, seeing no one else wishing to speak, we are going to close the public hearing on House Bill 107 and stand in recess until 10:20 for the purpose of introduction of House Bill 336. You've got 14 minutes, so Representative Wilhelm, your deputy ranking member is not here, but the Republicans are going to caucus real fast just to chat. So if you want to do so the same, I might recommend it. Get on the same page, opportunity to talk. But we'll see you guys back at 10:20.
Oh my gosh, great to see you. Been a while. I didn't recognize you from Michigan. Well, I just got old. We all get old. This is from my career. We're representing your up front. Billboard. Oh, really? That's a good memory. A lot of people here that it's long since retired. I mean, I don't like to retire. I don't know reason to retire. I'm too young to retire. Well, I remember, you know what this is? I can remember when he was in the legislature years ago. He'd bring his son to the legislature, bring him back, right? Yep. And how is he doing now? Now he's 36 and he's a college soccer coach down in West Virginia. He's in Vermont, St. Cloud, he went to Wisconsin, that's what about the pros. That was his favorite sport. He also played well, you wouldn't expect to see somebody from that far in the past.
Okay, we're going to reconvene. I'm going to open the public hearing on House Bill 336 relative to the placement of political advertisements on public right-of-ways. Representative Judy Aaron, you are recognized for the purpose of introduction.
Thank you so much, Mr. Chair and members of the committee, the Election Law Committee. For the record, my name is Representative Judy Aaron, and I represent the towns of Ackworth, Goshen, Langdon, Leominster, and Washington, which is Sullivan County District 4. I'm introducing this bill to you today, HB 336, relative to the placement of political advertisements on public right-of-ways. I'm here to help clarify the law after an incident that happened in Claremont this past election cycle. We had an incident where candidate signage was placed on the Claremont Green. One morning, members of Black Lives Matters began to illegally remove signs that were placed on the green, and so the incident, along with video footage, was reported to the New Hampshire Attorney General's office. The Attorney General's office then wrote a letter to the city manager citing RSA 664:17, saying that, and I've given you a packet with the letter from the Attorney General to Claremont, as well as the letter from Claremont back to the Attorney General's office. And so the Attorney General's office wrote a letter saying that the political signs are forbidden on public property and that their office, requested that all political signs be removed from public property immediately. This request was communicated to all candidates, and everyone scurried around removing their signage to take in any place that was a public right-of-way. The candidates were instructed that they had to come and pick up their signs. In the meantime, the city's manager's attorney, or the city's attorney, wrote back to the New Hampshire Attorney General with a different interpretation of the statute, plus identifying what they believed was an inconsistency in the statute. They wrote, quote, "Lastly, if you consider the overall statutory scheme and language of the entirety of this legislative act, you will have to arrive at the same logical conclusion as to the meaning of said statute. Another sentence in this law sets forth, quote, no person shall remove, deface, or knowingly destroy any political advertising which is placed on or affixed to public property or any private property except for removal by the owner of the property, persons authorized by the owner of the property, or a law enforcement officer removing improper advertising," end quote. That's in the law. They continued and they said, if your interpretation of RSA 664:17 were correct, then why would the legislature have to insert language prohibiting removal of said political advertising by non-authorized individuals on public property if such initial action, the placement of the political advertising, was illegal in the first place? Anyway, after their back and forth exchange, the city of Claremont granted permission for political signage to be able to be placed on their public land, and all candidates were informed that they could again put their signs back. For that couple of weeks, it was a very confusing and crazy time. People were wondering whether they could put signs up, not put signs up, where they can put them, where they couldn't put them, and so forth. And because there seems to be so much confusion over that, I brought this bill forward to try and clear up the statute and make it so that local municipalities can grant permission for signage to be placed on public land and publicly owned rights of way. And I look forward to your conversation on this issue and would be happy to answer any questions. And as I said, I've also provided the letters that were written back and forth regarding this matter.
Are there questions from the committee? Yes, Representative Newsom.
Thank you, Mr. Chair, and thank you for taking this question. Property rights in New Hampshire often go to the center line of the road for the landowner, and the right-of-way then goes out from that center. So there is an overlapping area where it is in the right-of-way, owned, controlled by the town for a road, and owned by the property owner. With this language saying, or by consent, could the town give permission to put signs in the right-of-way, which is otherwise private property? Thank you.
I would not, I don't believe so because we also say here, no political advertising shall be placed on private property without the owner's consent. So
Thank you.
you have both, you would need both consent from the local municipality as well as a private landowner if there was any kind of overlap.
I'm sorry, a follow-up?
Yes, follow-up.
I'm sorry, did you say you would need both or just one? Just the property owner?
Well, with the property owner.
Okay, perfect,
Yeah,
thank you.
Yeah.
Further questions from the committee? Representative Purnam O'Brien.
Thank you, Mr. Chairman. So I'm a little unclear on what happened exactly in Claremont that that made you want to file this legislation. And I know every community is different with the different traditions that they have for where people campaigning put signs. So was it the case that in Claremont there was a public area, like a park or a
They're green. Yeah, it was their
okay,
public
the
green.
town center, the town green.
Yep.
And historically, people have put signs there.
Correct.
People from all different political sides
Correct.
put signs there, and the town allowed it.
Yes.
And then some sign was there, and BLM opposed it. But could they have put their own signs there as well if they
Sure.
wanted to?
They could have put their own signs up, but they were illegally removing. You're not supposed to touch anybody else's signage once it's erected, wherever it is. And they were physically removing the signs. There was someone taking video of it and everything and reported that incident to the Attorney General's office in New Hampshire. And the Attorney General then wrote back this letter to the city of Claremont saying, well, you're not supposed to have anything on your public land anyway, so we want you to remove them because you're breaking the law. And they wrote back and they said, well, no, because we're giving permission, essentially, to put those signs up. So I don't know if they had gotten a response back from the Attorney General's office, but the city of Claremont granted permission for people to put their signs back up.
Further questions from the committee? Hearing none. Thank you, Representative Aaron.
Thank you so much. I appreciate your time.
Next up is Representative Dry. Welcome to election law.
Thank you, Mr. Chairman. Thank you for hearing this bill. For the record, my name is Representative Margaret Dry. I represent Sullivan County District 7, and I am in support of this bill. I just want to add a piece of experience as an EMT and a rescue personnel for driving around when it's political season. In our town, unfortunately, it gets around by rumor whether or not political signs are allowed to be placed on the right-of-way or certain sections of town. And unfortunately, people take advantage of that and put things around stop signs, yield signs, and places where it distracts drivers because it draws attention to this area below the sign and not the stop sign, especially on country roads where it's sharp corners and often blind driveways. I like this because it makes it more of the onus on asking for political subdivision permission. I just hope that political subdivisions understand that they need to be very specific because people interpret what they mean by public land as a lot of different things in a rural area. And I just wanted to bring up that point as we're working on it. I know it says you can't interrupt the safe flow of traffic, but a sign near a stop sign doesn't necessarily interrupt the flow of traffic, but it does interrupt the safety. Thank you.
Will you be taking questions from the committee? We have to say yes or no. Yeah.
Oh, yes.
Okay. Are there questions from the committee? All right. Seeing none, thank you.
Thank you very much.
Next up is Sarah Burke from the New Hampshire Municipal Association.
Good morning. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. The NHMA supports this bill. This bill clarifies the law currently where political advertising can be posted and the consent that must be sought should it be on public property and or private property. The language contained in this bill is consistent with property ownership and highway law related to rights of way. I'll take questions.
Are there questions from the committee? Seeing none, thank you.
You're welcome.
I don't have any more pink cards. Representative Gosofsky, I'm working on. Did I get it right? All right. Can you pass me that blue sheet? And online we had 6 in support, 3 opposed. Is there anyone else wishing to speak on this bill? Seeing none, we'll get this blue sheet and close this thing up. Okay. All right. Spoke. Okay. And sign up on the blue sheet who did not speak. 1 in support, 1 against. With that, I'm going to close the public hearing on House Bill 336. And we will stand in recess until 10:40 for the purpose of introduction for similar subject requiring HB 423, requiring the consent of property owners for the placement of political advertisements on public property abutting their land. Oof. All right. See you guys at 10:40.
Good morning. It's 20 of 11, and at the request of the chair, as vice chair, will be opening the public hearing. I am opening the public hearing for HB 423, and I recognize Representative Weiler, excuse me, thank you, to testify for the bill.
Thank you. Representative Ken Weiler, Rockingham 14, my 19th term in the House. For the last 30 years, I believe that RSA 664-17 gave me, as the abutter, the right to control who placed political advertising on the corner lot where I live. I would take the sign of a candidate whom I did not support, lay it on the ground, place a copy of RSA 664-17 attached to it with a note that I was the abutter and this sign does not have my permission. Sometimes it took more than one notice to cause the sign to be taken away, but generally I had cooperation and the signs were removed. The last election, I had one candidate who had a very aggressive campaign attacking the candidate whom I supported. I had to remove her sign 3 times. One of her workers came to my house to argue that I had no right to do that. Her campaign manager made a fuss, and since he had earlier worked with the Attorney General, he got that office to send me a cease and desist order. I passed out about a dozen copies of that, half a dozen copies of that. I didn't make enough for everybody. The cease and desist order made no sense. It referred to the abutting highway as being purchased by the state under fee simple and gave the impression that the law only applied to abutters who owned the land over which the road passed. That would be a Class 6 road and would have so little traffic on it that it would not attract any political advertising. I've changed the wording of 664-17 to make it clear that the abutter has the right to object to political advertising, the right to remove it from display by placing it flat, place a copy of this RSA on it with the abutter's name and address. I hope that the committee agrees with my reasoning and takes the opportunity to make this law clear and approve the action by an objecting abutter, excuse me, which otherwise is lacking. The law says you have to have the abutter's permission, but it doesn't say what you do if you don't have it. So I'm trying to put the language in there to make it clear you don't just slash it or tear it up. You have to treat it with respect, lay it flat so it's not on display, and then put this note on it, which is what I've been doing for 30 years, and most people respect it, until this person made a fuss, and she lost anyway. But anyway, I'm trying to make it clear that if the law said, if it's on state right away without the objection of the abutter, that I wanted to make the language clear because obviously this Attorney General did not understand it. So I hope you can support it and improve the law and this law gets amended every few years anyway, as you've seen. So that's my hope. Thank you. I'd be happy to answer any questions.
Thank you, Representative. Are there any questions from the committee? Representative Muirhead.
Thank you, Mr. Vice Chair. Looking at the proposed legislation, it looks like it makes 2 changes. One is it has this process for what to do when there's something there, which I appreciate. And another thing is it changes the language from owner of the land over which the right-of-way passes to property owner who's the closest abutter. And in thinking about that change, it gave me just a little bit of caution because I'm thinking about, for instance, an intersection in Newport where a couple state highways intersect and there's a state park there, and the nearest abutter is actually quite a way away from the intersection. But now under this language, the nearest abutter would have the ability to come in and monitor the signage, even though their property is not actually very close to that intersection. They're the closest abutter. And so I wonder, could we keep the old language that says over which the right-of-way passes?
Well, if we have an Attorney General who assumes that's a Class 6 highway and goes on about the fee simple. Oh, no, we bought that, so you don't have any rights. Nobody knows who bought the road that goes by their property. You don't know whether it's fee simple, Class 5, Class, I'm on a class, so I'm on this corner, Class 1 and a Class 2, where Class 2 is going to a state park and Class 1 is a major highway. Okay, I wouldn't have any right, according to this Attorney General, because they bought it under fee simple. I'm trying to straighten him out. It's got to fit in one of these classes. And if it claims the right of way over which the road passes, the right of way over your property, that's a class 6 road. Where you own, if it's abandoned, you own to the middle of the road. So in effect, you have some ownership of that road if it's discontinued as a right of way. That's the misunderstanding that I'm trying to do away with, which obviously this Attorney General says, oh no, we own this fee simple, and it only applies to the landowner right of, and I said, at one point, the property I bought, that highway had been widened and had been taken from the property that I bought. So is that the owner of the land over which the right of way passes? So no, well, no, we owned it under fee simple. You don't seem to understand. Why would I put advertising on a class 6 highway? Nobody goes down it. But that's his interpretation. So I wanted to make it clear. Now, in this case of so here's the land, it comes across like this. Then there's a couple of islands. I don't have anything to do with the islands, I figure. So it's the same thing. I'm the nearest abutter to this corner. But if there's something intervening in the way that is public stuff, then you're not quite the nearest abutter. As you say, there's a park and there's other things. I'd have to look at the intersection to give you a real good answer, but I don't think the nearest abutter, if you're 200 feet away and you can't even see it. But the idea is, everybody knows who I am, who I support. If somebody I don't support sticks a sign in front of my property and somebody says, I voted for him because you had a sign there, that wasn't who I was supporting. But I couldn't remove the sign because I had a cease and desist. That doesn't seem right. If the first written law said you needed permission of the person over whose property the right-of-way passes. And so if it's going to be misinterpreted by an attorney general, I wanted to make it a little clearer. So I put in the nearest abutter. I hope that situation is rare enough that somebody says, no, you weren't the nearest abutter because all this public property was here in the interim, which wasn't owned by you and it wasn't part of the right-of-way. So that was my interpretation. Do you see my point?
I do, thank you.
Thank you.
Are there other questions from the committee? Okay, Representative?
Thank you, Vice Chair, and thank you for taking my question. I'm just curious about the mechanism for remedying when you find these signs, objectionable signs placed. If you were found removing them, would an alternate possibility be to contact authorities to ask them to remove it rather than have you as the abutter removing them and kind of running the risk of being misinterpreted or misconstrued as removing signs improperly?
When I go to remove the sign, I have a copy of 664 in my hand that I'm going to tape to the sign. If anybody comes and says, hey, you're illegal, say, read the law. Here I am. I wrote my name and address on here. I can show you my ID. I'm the guy that's written the note. I'm leaving it on the sign. Otherwise, it might take 2 weeks before the authorities got there to remove it. Or it wouldn't happen immediately. But I've had signs that somebody complained about blocking their view. They were gone pretty quick. But, I'm not sure if I called up and said, I don't like so-and-so sign, whether they'd get to it right away and say, yeah, we'll get to it. I just figure that, especially if it's the same person I've sent the note to, they just ignore it and put the sign up again. I'm going to take it down again. The town might not be that quick. So, but I think we do need to describe in the law what you can do if you object.
Representative Newsom?
Thank you very much. Thanks for taking my question. Looking at 664-17, which is the statute that you cited as giving you permission to take down these signs, it says no political advertising shall be placed on or affixed to any public property, including highway rights of way or private property, without the owner's consent. Does your bill expand that to then abutters? So if that right of way is across my land, you as a abutter would now have control over what signs I put up? It seems to be these two, the bill and the existing statute, are in conflict.
How do you feel? So where is your property and where am I the nearest abutter?
Well, I'm just looking at the statute that requires the permission from the owner and not, doesn't mention the abutter at all in 664-17.
So if you were renting a property and you were well-known in a certain party, and somebody else stuck signs in front of you, and they said, you have no right to remove it. But I'm saying if all of a sudden people say, what, did you change your party? Why are you supporting him or her? And, you know, this way it's clear, if it's sitting in front of where you live, then you should have the right to say, I don't want that sign there. So I think that's what the original law intended. And the original law assumed that everybody lived in a house that they owned, rather than rented or whatever. But it seemed to work for years until these people start dealing with attorney generals that don't know the difference between a Class 5 and a Class 6 road. So, and especially,
Yes, go ahead.
What exactly is the difference statutorily or whatever with the 5 and 6? Because I thought that the default rule in New Hampshire is that the landowner owns to the center of the road, not just on Class 6. It certainly happens when a Class 6 road is thrown up, that then the two abutters along that right-of-way own to the center line. But
on a
they own that either way, even if it's not given up in many roads, that is the default in the state. That was my impression, at least. We may disagree. That's
no,
fine.
No, the Class 1 road, not only does it take all the pavement, but it has the shoulders and the drainage ditches and all that, and it may go anywhere from 35 to 40 feet. And so it turns out that most of us mowing the grass, we're mowing the state's property. And that's why we put a law in there with an exception. Let's say you mowed your neighbor's grass for 20 years. You could claim it was yours. You can't do that with the state right away. We put in a specific thing. Most people don't know where the state owns to. And every once in a while, when I look at a map and go to the registry of deeds, it varies. It's what was available for them to take. In some cases, it goes 20 feet into what you think is your property. And that's what they bought, because that was what available when they put the road in. And that's what they decided to take. And sometimes because of drainage ditches and culverts and things, they took a little more in some places. So very few of us know exactly where the edge of the state's property on the road and our own is. So I just want to make it clear, since they could put something right almost next to my steps and say, oh, I just looked it up in the county. They actually own right up to your steps. And I'd say, wow, I hadn't gone and looked at that. But that's the way some of the properties are. When I researched them, I was on the planning board for years, and we look at these things, and it would vary. And sometimes they took so much land, they'd be willing to sell it. And one of my neighbors, they took a piece of property that would have allowed him to expand his business. And I called up the real estate people, and they were very slow in getting back to us and saying, we haven't decided yet. But he's been trying for years to get this piece of property because they took a whole house lot. They were moving the road apart, expanding the highway. This was again on 125. And it came so close to the person's property, they didn't want to keep the house anymore. So I think it came right into the house. So they said, all right, we've got to take the whole thing. So now they got, that house was fairly close to the front of the property. But once they took the house, it was another 200 feet behind it that they had to take. So here's their abutter wants to buy that piece to enlarge his business and still stay far enough away from the highway. So you never know exactly how wide that right of way is that they took, is my point. I've discovered that from years of being on the planning board. Thank you.
Representative C.
Thank you for taking my question. You'd mentioned tenants, and I just got to wondering what happens if the tenant and the building owner don't agree?
I think the building owner would have the right to say, I don't want this on my property. It's not included in your lease. So, but I've seen it happen both ways.
Representative Toner.
Thank you. I just had a question. So I'm just trying to play this through my mind. So in your situation, for simplicity, is it a scenario where basically you have whatever main highway going and say your property lines are perpendicular for simplicity to that highway? And obviously they can own 50 feet, 100 feet off the center line up into your property. Is that the scenario that's playing out here, that basically someone put a sign right up next to the edge of the highway and it happens to be in between more or less the property lines of your piece of property?
Yeah, my property runs about 1,000 feet along 125. So I sometimes use that as I am the abutter. And then my house faces on another road that goes into 125. That's where I live, and then it goes around the corner. But my property abuts both the highway and the road I use as my address. So I own the corner lot, which I say gives me control of the corner. And as it is, I abut 125, as I say, for 1,000 feet. So I assume that I could say anywhere along there, I object to this. That's what I'm saying. So it would, in my mind, I'm the nearest abutter. So, but here's this little islands that go like this. I don't try to claim control over them because they're between the road, this road and that road. So lots of things get put on those islands that I object to, but I don't figure I have the right, the same as I do where I'm in a butter. Thank you.
Further questions from the committee? Representative Harvey Bolia.
Thank you, Mr. Chair. Just a quick question. I thank you for bringing up this bill because I've often wondered about this sort of piece of law. But assuming, I'm thinking of Samberton Center where there's an island very popular for sticking signs in, and I don't assume you can see all the way over, but assuming there's an abutter, there's two roads sort of intersecting, and there's an abutter on either side. They have differing political opinions, I know. How would that work out, would you say? Where they're kind of equidistant?
They don't abut that diamond. On their side of the road, they're in a butter. But the diamond,
Yeah,
nope, that's
just frontage
Free.
then. It's
Yeah.
frontage,
If there were
okay.
2 lots on the inside there, that'd be a problem.
Excuse me?
Yeah.
One person at a time speaking. And I would like to make a note that if we could stick to the specifics of the bill with regard to our questions, I think that would be more helpful. Thank you.
No, I want to make it clear that not only the rights of way, the state's rights of way that abut your property, but also the method you have to do if you object. Because the present law doesn't give you any way to deal with it. That's the point I want to make. You might end up combining this law and the previous law, or however you want them to do it in the committee, but I hope you keep both the rights of the abutter and the rights and the method to deal with something you object to. Otherwise, it's not in the law.
Thank you. Are there any other questions from the committee? Yes, directed more towards the specifics of this particular bill. Thank you very much, Representative.
Thank you for your attention.
I see no further. Oh, I see a red card coming, indicating someone else would like to testify. Okay. Next, thank you. I didn't read it. Thank you. All right, see no further red cards indicating someone wishes to testify on this bill. I will call the meeting to a close, adjourn it at 10:59 a.m., just in time for the next public hearing. Yes, I have the blue sheet. I see 2 people wanted to state their views without testifying. One was in favor of this and one was against it. I do not have the online as well. It being 11 a.m. exactly, I will open the public hearing for HB 448. Okay. The acting chair recognizes the prime sponsor, Representative J.D. Bernardi. Thank you for coming to testify today.
Thank you, Acting Chair and the Election Committee. I am Representative J.D. Bernardi, Rockingham 36, Hampton Falls, Kensington, Southampton, Newton, and Plastow. I'm here to introduce HB 448, which establishes a committee to study violations found in the 5 April 2023 Ballot Law Commission. I have given you 4 of the summary books of that commission. And if more are needed, we can get those, as well as Representative Brandano behind me will show you the full compilation of all the violations in a larger text that may be useful. So what is this all about? This was Senate District 24 2022 election. Was investigated by 700 hours of lay volunteer work to basically document the problems that they found with various election law violations in that election. The results of their work was presented to the Ballot Law Commission by Attorney McDonald, and after reviewing over 100 documented violations in many areas, they referred the issue to the Attorney General. Now, what kind of issues are we talking about? Talking about absentee ballot controls and reconciliation. We're talking about the counting machines, qualifications, and operations. We're talking about multiple chain of custody issues with inappropriately sealed boxes, missing signatures, inaccurate vote counts, things in the wrong boxes that are totally mislabeled. So over 100 violations were noted, and including over approximately 2,400 moved voters, people who had moved out of the towns still on the registration lists. So, and lastly, missing the required continuity of operation plan, which every town is supposed to have for when things go south during your election process. So all these violations were heard and acknowledged by the Ballot Law Commission, and they did not believe that they had the authority to take any action on them, but they believed they were legitimate violations. So they turned them over to the Attorney General. The Attorney General did not pursue these in any kind of court proceeding. I asked the Attorney General why, and it's very simple. New Hampshire election laws do not have attached penalties. So we say, put all the ballots in a box, seal it with tamper evident tape, and if the box shows up, tamper evident tape's clearly been dislodged, the signatures across it are missing, the boxes are still accepted in a recount procedure, even though you have no idea if they've been opened or tampered with, and evidence shows that. So that's just one of many violations that we've seen here that they reported, and they're summarized in those smaller books, and a larger book lists every single violation that occurred. So yes, why do I raise this issue? It's because I've spoken to many members of the legislature on election committee in the past, election law in the past, and they say, well, the number of violations we have are minor, they're not that many, they're infrequent, we don't need to deal with that. I think this particular episode demonstrates the falsity of that assertion. We have many, many of these kinds of problems. And it calls out, and the documentation submitted to the Ballot Law Commission basically asks that 3 issues be addressed. Additional training for the people in the process of managing our elections, further auditing of the process, and finally, attaching appropriate penalties to the violations that are observed. So when violations occur, and they can be referred to the Attorney General or the Secretary of State, whatever office you believe is appropriate for addressing them, they can take appropriate action. What we have here is a system that continually causes concern by individuals in the public saying, is my vote really being counted when I see all these violations? Is my vote being tampered with when I see all these violations? And nothing happens. So this committee, I would actually prefer you look at all of election law and deal with training, auditing, and penalties. But in order to put a stake in the ground that this is real, I took this massive number of violations seen by the Ballot Law Commission, validated by the Ballot Law Commission that these are real, this is not fantasy, and present that to you as a grounds for moving forward. And happy to take any questions.
Okay, thank you. Do we have any questions from the committee? Representative Ward? I'm sorry. Representative Wood. I
That's
misunderstood.
fine. Thank you.
Okay.
Well, did I jump ahead of you? Okay. Thank you for taking my question. It seems to me that you're bringing this forward to just continue the process of someone looking into this. Is that true? Or have we found any other problems to why? Can I ask you why you're bringing this forward at this point?
I bring it forward because it's clear documentation of the kinds of problems that we've seen, and I asked for a committee to study it, to not, you can't undo what has been done, but put together procedures that will limit these kinds of problems in the future. And that boils down to training of the people that are conducting the elections, auditing to make sure that you really are implementing those training procedures and people are following the law as written. And thirdly, penalties that ascribe to the violations so that they're just not ignored. And that's the problem that we have. We have, you can look at these violations and say, oh, this is just a little minor thing. But if this is repetitive and ubiquitous, over and over and over again, we see these problems. You have an electorate that's saying, I don't trust the process, and we do not want to be there. So I want the committee to pass this bill and establish a committee that will make recommendations to our election law to change it to address those 3 things.
Okay, thank you.
Okay, further questions? Representative Ward.
Thank you, Mr. Chair, and thank you for taking my question. When you started out your testimony, you spoke of 700 hours of lay volunteer work. Can
Yes.
you characterize, is that a group?
Yes, there were several individuals involved in the election area of District 24 from the different towns in that area, and they collectively looked at what happened in their respective towns and scoured through, what happened during that election and compiled their observations, which were then brought before the Ballot Law Commission.
So not an organized group.
It's not a defined entity. No, these were willing citizens looking at what's going on and concerned with the election process, particularly in that particular election.
Thank you.
Further questions? Representative Prudhomme O'Brien.
I have a lot of questions. I'm trying to organize them. Could you remind us who the candidates were in 2022? I did look up some information about that district, and I see that it's pretty evenly split, Republican, Democrat, demographically. But who were those candidates that year in 2022 for Senate?
That was Lou Gargiulo as a Republican candidate and Altschiller as the Democratic candidate. The district tends to be more. It's not evenly split. It's more of a Democratic district because of the town of Exeter, which is very strongly Democratic.
Okay.
You should like a follow-up?
Yes,
Go
I
ahead.
have a follow-up. I'm just thinking back to some difficulties that I also experienced in my own community regarding similar issues. And a Senate district is, of course, much different. You've got many communities that you're working with. Did people in those communities come forward and make reports about specific election law violations within their community to the Secretary of State and the Attorney General's office in an effort to fix that problem? And that's what I recall having been done in my own community.
There were reports to the Secretary of State office by the members of individual communities, but then the work was done to consolidate everything that happened in all the communities involved in District 24 to create this consolidated list of, we have these problems here and those problems there, and let's put it all in one big report, and let's bring this to the Ballot Law Commission. And that went to the Attorney General. I do not know if any individuals went directly from their community to the AG's office. I don't think that happened, but it may have. Al Brandano behind me could probably better answer that specific question.
Representative Wood.
Thank you, Mr. Chair. Regarding the action of the commission, what was their action? I know you mentioned, I just want to make sure I'm clear. What was their action? What was their recommendation out of this?
Their recommendation was that these were legitimate findings and that they couldn't take action on them. So they referred, because they considered them violations of the law, they referred them to the Attorney General for his action.
Thank you. That was very clear. Thank you.
Representative Muirhead.
Thank you. I wonder if you could help me with the phrase, the April 25th, 2023 Ballot Law Commission, and what that refers to. When I look at the Ballot Law Commission page on the Secretary of State's website, I see meetings that were held on April 5th, in 2023, and a meeting that's held on May 25th, 2023, but not a meeting that was held on April 25th, 2023.
No, it's April 5th. This is right. Did I say 25th? If I did,
Bill
I'm
says
sorry.
April 25th, Mr. Chair, is that?
That's what it says in the title of the bill, April 25th.
That's a typo. It's the 5th of April. In fact, the document should say that you have.
Okay, thank you. Follow up?
May I ask whether the minutes of the April 5th meeting will have a discussion of these violations?
Certainly.
They should, yes.
Okay. Representative Wary.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Just want to clarify, you've mentioned the three aspects. I saw the Ballot Law Commission presentation and am familiar with it. So thank you for bringing that up. You've mentioned training, auditing, and penalties. However, the scope of duties on lines 10 and 11 seem to refer specifically to the penalty aspect. So is it your desire to have both training and auditing as well as the penalties?
if you look at the recommendation in the actual documentation presented to the Ballot Law Commission, those are the three areas that they call out. I agree with them. When this bill was written, it was just it focused in on the penalties, because if you don't have a penalty for breaking the rules, you're never going to get anywhere. It's the only way you're going to get attention of people who don't follow the rules. Now, if you want to get better compliance, you're going to train and audit as well. That's only logical. But ultimately, you're not going to enforce compliance without a penalty.
Further questions from the committee? Representative Gilmore.
Thank you. Do you have a list of these violations?
Yes, they're in a larger book where I think there's 121 total, and Al Brandano behind me has that book.
Does he have? He's going to disseminate that.
That if the committee wants to move forward with this, so we can make copies of that and have that available. Yes.
Thank you.
Further questions from the committee? Seeing none, thank you very much, Representative Bernardi.
Thank you.
I'm going to call Secretary of State David Scanlon next, and then Mr. Brandano. Thank you, Mr. Secretary.
Thank you, Mr. Chairman and members of the committee. I'm David Scanlon, Secretary of State, and I'd like to provide some information just to put this issue in perspective for the committee. First of all, what's going around the room are the minutes from the Ballot Law Commission meeting where they took this issue up, and then the second document is the response from the Attorney General's office after receiving the request from the Ballot Law Commission. In terms of elections in New Hampshire, the process that has developed over a couple centuries is both a blessing and a curse. It's a blessing because the elections are run by we the people. Citizens from every one of your communities are elected by their neighbors, friends, family members, and general community members to do these jobs that are pretty important. And hopefully they get elected to do those jobs based on their integrity and the ability in the eyes of the community to do that. The process itself has many checks and balances in it, so that after the election is over, if there's a close race or even a not so close race in the case of the Senate District 24 recount, where the difference between winning and losing was over 3,000 votes, there's an opportunity for a recount where the ballots can be reviewed and challenged further. And if there are ballots that have been challenged for further appeal that might make the difference in the outcome of the election, that issue can be taken to the Ballot Law Commission, who will make an additional ruling on whether the intent of the voter on those ballots was accurately recorded or not. And then ultimately issues can be taken to our state court system for additional adjudication and review. Because the citizens run the elections in this state, they are not perfect, and they never will be perfect, even though that's what we strive for. There's just a human element to this that is prevalent. I would compare it to a classroom where you have some students that are going to get all A's all the time. You don't have to worry about mistakes on their tests. And then you probably have the larger bulk of students that are going to be in the B, C+ range, where they're not perfect all the time, but they know enough to get the job done. And then there are going to be people in the class that simply are going to fail. And the election process that we have really is no different, because of collectively, we're dealing with a representation of society as a whole. And we don't have all A students that are running our elections that are going to be perfect every time. And I think the report that you have seen is expecting that. And I don't think that that is particularly realistic. Now, we do have laws on the books, and the laws have to be followed. And to help the local election officials do their jobs as accurately and efficiently as possible, we do a significant amount of training, and that training process is growing all the time. When I first started working in the Secretary of State's office, it was in the year 2002. So I've been at this for quite some time. And I can tell you that when I started working in the office, and this is part of putting this whole thing in perspective, there was nothing uniform about the processes that were taking place in polling places around the state. This was the set of statutes that we had in the 1998-99 session and compared to the statutes that we had today. And you can see today's book is about twice the size of the book 25 years ago. This was the election procedure manual in 1989. This is the election procedure manual today. And when I went around to polling places, when I was first serving as Deputy Secretary of State, we would walk in and the processes that were taking place were clearly not consistent with what the statutes required that they be. And when we would inquire with the local election officials about how that process is working, they said, well, we never looked at the law. That's just the way we've always done it. And so we've come a long way in 25 years. During that time, there was the passage of the Help America Vote Act. It required that we have a centralized statewide voter database, which we've just replaced now with a brand new system. But up until we created that in around 2006, every municipality in New Hampshire maintained their checklist in their own way. And that ranged from really nice spreadsheets in the major cities in New Hampshire to hand-recorded checklists in the small towns like Orange, where after every election, they would handwrite out a brand new checklist. And that's how they were maintained. So, we've consolidated. We had to aggregate all of that information, all of that data. We had to put it in a uniform format, get it into the database so it could be properly used. The training that we put on now, as I mentioned before, is very extensive. We do it both in person and online, and there are dozens of opportunities every year for local election officials to get trained on the proper procedures and processes that should take place in a polling place. And we are seeing improvement, but that's going to be an ongoing job. We're talking about probably close to 3,000 election officials that are assigned these duties, not volunteers that help on the election day, but actual officials that are involved in this process. And as you can imagine, there is constant turnover in those numbers after every local election. And so the training is ongoing, and it is always from scratch to more involved processes in the polling place. And so along with that, there are varying degrees of ability. Brand new people that have no idea about the total text that is in this document versus some long timers that have been around a while and they know how to do things properly. So, I am sensitive to the issues that have been raised. I don't think that they raise to the level of the integrity of the election itself being jeopardized. I think if the people on my staff at a recount or visiting polling places noticed ballot boxes or things that were in a condition where they needed to be investigated, we would do that without hesitation. But I think for the most part, the election officials that we have in New Hampshire are dedicated. They want to do a good job. I think for the most part, they do an excellent job. And I would hate to see anything occur in the form of legislation that is punitive. And this study committee is designed to look at being punitive when the mistakes that are made are technical, clerical, and certainly not intentional. So with that, I would be happy to answer questions the committee might have.
Thank you, Mr. Secretary. Do we have questions from the committee, bearing in mind we're now a bit over schedule? And if we could, I can't enforce this, but if you could try to keep the questions to the subject of the legislation as discussed so far. Okay, thank you, Representative Wood.
Thank you for taking my question. So it seems to me that the concern, I don't want to put words in your mouth, sorry. What is your concern with this bill? Which side are you on? I didn't get that from your explanation.
Well,
if you could
the
help
concern
me.
is, I think it's good to be skeptical of the processes that we have, and it's good to have oversight. And I've always said that the process needs to be completely transparent, or as transparent as it can possibly be. And I think the intent of this bill is certainly in line with that. What I would hate to see, however, is in the bill, if you look at it, there's language to look at it's punitive, to look at, what the remedy would be for penalties that would be applied. And I don't think that if we do that, we're going to discourage people from stepping forward to perform these roles, because they're going to be concerned that if they make a technical error or just a simple mistake, that they may be penalized for it and guilty of a violation of law. And I think the important thing is to continue with education, and we're doing that. Certainly that requires resources, and if it's the judgment of this committee and the legislature that we need to do more, then I think we need to be prepared to pay for it. And I think that answers the question.
Yeah, thank you. That's perfectly clear. Thank you, Mr. Secretary.
Other questions from the committee? Representative Wary.
Thank you, Mr. Chair, and thank you, Secretary, for taking my question here. We've had a couple of forensic audits of a particular community in the past where there's been sort of redundant non-compliance. How would you advise handling those situations, and what did the Secretary of State's office and the Attorney General's office do in that particular circumstance?
For the longest time, we never had to use monitors because of situations that occurred in polling places. And more recently, there have been situations that have been identified as going beyond just normal technical failures or errors, but just actions of election officials that were not appropriate, and in violation of more significant parts of the election laws. And when that occurs, we're supposed to put monitors in the polling place. And so over the last 2 or 3 election cycles now, we've had monitors probably in 2, maybe 3 polling places in a given election. There was one town in particular that has had monitors now in repeated elections, and we're taking progressive additional steps to try and deal with the issues there. Ultimately, the towns have a responsibility in this too, and the people that they elect to those positions have to be qualified. And the members of the community, the voters in that community, need to recognize when those jobs are not being properly executed and make the required changes. I know that the Attorney General's office is the enforcement arm of the election laws. They are the ones that will conduct any investigations, and they will make decisions based on those investigations. And there have been a couple of instances where election officials have been actually removed from office because of inappropriate activity to the tune of just mishandling individuals' votes, voters' votes, or trying to cover up flaws in their process. So, we continue to tighten the screws in that regard too.
Yes.
Do you think in those extreme situations that you just described that punitive measures ought to be put in place?
Yes, and I think they are in place. The punitive measures were exercised by the Attorney General's office.
Representative Gilmore.
Thank you. Dave, we're just talking about, basically, this bill is just targeting local elected officials, not state personnel, as I understand it. Would you agree with that?
I think that's true. I think that all of us have to be accountable, but we have to be accountable in the appropriate way.
Yeah. But that was the ballot law commission process. And okay, thank you.
Yes.
Further questions? Representative Prudhomme O'Brien.
Thank you. I don't want to minimize the problems that have been discussed in this proposed bill. I think they are very important. But I go back to some of what you're saying and how it applied in my own community, where I had some concerns about election, some violations in election law, and it didn't make much, it didn't get a lot of traction, let's say, until the AG in your office, after their investigation, had a monitor sent to my community, and that action was kind of embarrassing, and that got the attention of the public. Would you say that going through that process, and things did improve in my community, thankfully, but would you say that going through that process is the best way to draw attention to it? That's what I found in my community.
Well, I think it is a good way to address it. And as you mentioned, the community should be embarrassed if they have to have a monitor. There is a bit of an issue with the monitor process itself, and that is finding individuals that are qualified to be monitors in a polling place on election day, because the pool of people that would have that experience and expertise are serving as election officials during an election. So we have used some elderly attorneys in the past that have had election experience, and we've tried to use some young attorneys in my office, trying to give them some exposure to these processes, but they're on a sharp learning curve as well. So, we continue to, that process continues to evolve.
Further questions from the committee? If not, I guess not. Oh, thank you very much, Mr. Secretary. Always a pleasure to see you here.
Always a pleasure to.
Next up is Mr. Brandano. Thank you. Thank you for being here today.
Thank you. My name is Al Brandano. I'm from Kensington, New Hampshire. And I'm kind of disappointed because I look around me. In the last 4 years, this room would be packed. And that's not the case anymore because people have lost confidence. Because for the last 4 years, when we came before this committee, not a handful of the bills of the 40 things that we brought up for election integrity was addressed. And respectfully to Secretary Scanlon, he had a voter confidence committee where hundreds of people across the state attended. Ask him what happened with the results, what actions have they taken. So sadly, this is where we're at, and it's very frustrating, but I'm here to do the best I can on behalf of the people who have given up. First of all, this audit happened, this citizen audit happened after the recount election of Senator who was running at the time, Lou Gargiulo. About 50 people joined in on the recount from Lou's community. There was 7 towns, 50 people came together on the recount that happened at the Secretary of State's archive building. During that process, we became not only motivated, but horrified of what we witnessed. From taped, one of the big things in the contention for me in hearing Secretary Scanlon is that he's missing a very important point, and that is chain of custody. Chain of custody is broken. You can't count anything. In fact, if chain of custody is broken, it's all broken. You can't say, well, the boxes were broken, or we mistaped them, or we used the wrong tape. And it's unacceptable. Once the chain of custody, the rest of this is incidental. It really doesn't matter. Chain of custody is everything, and we should be really focused on that. And so after that process, about 8 people came together on Lou's behalf and went through about 800 hours of work, and you'll find it here, and I'll produce it for you. Every complaint in this has been verified, and we have the documentation with pictures and RSAs, laws, not just infractions, but RSAs that have been violated. You'll find that there's some towns like Exeter over and over and over. They've been noticed by the Attorney General and Secretary of State. We can go on, and I'll produce this for you. But everything that you find in here, we have produced in paper form as actual evidence of violations of RSAs, not just incidental things or policy procedures or failures. So I want to make that clear. The second part here that really concerns me is that if we don't do something and we continue on the same path, that we just say, you know, it's okay, they're minor infractions and nothing's going to happen, doesn't matter. What's going to happen? Where are we now? Like I said, I'm one person here. There used to be this place, you remember it, you were here, it was packed. Nobody believes anybody. When you take it to the community, when you take it to the Ballot Law Commission, and they send it to the Attorney General, and they're not going to investigate, because if you look at the Attorney General's letter, he says specifically, it's not up to us. You didn't point out the person. If you look at what he said, you didn't point out the person that you want to claim violated the law. That's not my duty. We're citizens. That would be vigilantes. And it's unfair to understand that that's what he said in my non-lawyer language. That's unacceptable. The people came together, did this work, gave it to them, and nothing happened. And they told us, you didn't identify the person who committed the crime. Well, we just let you know that somebody was robbing the bank, right? That's all. We don't know who it was. We saw the car drive away, but that's not our job. So you'll have to excuse I hope my harshness and my passion, but I'm really, a lot of work from a lot of people, and they're quitting because they see no hope. And I only see the hope in this committee that you will pass this bill. No one's out to hurt anybody. That's not doing anything. Habitual offenders need to be taken care of. It can't continue like this. I'll take any questions.
Thank you very much. Do we have questions from the committee? Okay. Representative Wood.
Thank you, Mr. Chair. And thank you for taking my question and for the hard work you've been doing. How do you see this bill helping? You said that you haven't seen any action. How do you see this bill making a difference, please?
Because if you look past the last 4 years, what's come out of this committee is really nothing. The only thing that's really come out that has actually hurt us, I think, is HB 154. And there's a whole, that was a bill that was hidden within a healthcare bill, which changed 22 election laws, which frustrated so many people who come here every day and try to do the work of the citizen. So what happens is this is a starting point for people to have hope. Hey, all we're asking for is that there is a review of the rules. Because training, let's be honest, is not it's only voluntary, right? I mean, it's not mandatory. I don't know. I believe the training rates are less than 50%. I think the Secretary of State will have to tell me of the people who participate. So we have a training issue as well, but there's a habitual offender issue and also a chain of custody. We really need to crack down on the proper chain of custody, because if you don't know what's in the boxes, it doesn't matter what the count is.
Thank you.
Further questions from the committee? Appears not. Thank you very much for your testimony today. We have another pink card, Diane Fisher. Oh, well, thank you for being here today. Would you press the button on your microphone?
You can see
Thank you.
how good I am at this. As Mr. Scanlon said, Secretary of State, I am a citizen and I make mistakes. But my name is Diane Fisher and I'm from Hampstead, New Hampshire. And I'm going to tell you a little story. I came home from a trip a few days ago and I had no hot water. The pipes had frozen. I called my son and asked him to come over, and he used some kind of a heat lamp or whatever and got the water flowing. And then we found it was fine. And then we went through the house and we looked around at the pipes to determine whether or not there were any leaks or breaks. And as he said, we need to make sure of this before anything and more damage happens. Well, I look at this committee and I am really thrilled to be in front of you and an august committee of people that can make a difference here in our state of New Hampshire and what we're doing. I look at this system as a chance to look at a leak and make sure it's not there. I knew something was wrong. We know something is wrong. I have this. I have pictures on my phone of when we were there in the archives building and when we spoke and we told people of what we found. And we weren't looking to blame people. We weren't looking to make fun of people or look to penalize people. We wanted them to see. Isn't that something we do all of the time? Isn't that what we have heard so desperately? If you see something, say something. There is not one person, I would imagine, in this room that has not heard that. Or have we not listened to it and known of the importance and what it is? Well, just like I saw something when no water came out only on one side, I saw something here. And I have seen it consistently through many times, many elections, whether they be recounts or things in my own town or other towns. I was brought into this and looking at it when I had, as they say, no skin in the game. I'm from Hampstead. I'm not from Exeter. I'm not from these areas where others were represented and were talking. I am from America. I am a U.S. citizen. I am a New Hampshire citizen. And I want and I pray that you listen to us, that you look at this. If you haven't seen it, you should take the time and you will see the documentation. You will see, as Al has said, 700, 800 hours, and I believe it's more, of people that came and gave of their own time. I'm a grandmother. I started out with this because of wanting things for my children, for my grandchildren. I then went on bigger. It's for more than my town, other towns. It is for the country in general. It is for everyone, for all of our lives, for our very liberty. We are here. We are asked to support our state, to do our duty. And our duty is to help keep the election process open, fair. And another reason, and I was listening to what the Secretary of State said, we do not want to be punitive. And yet, a couple of sentences later, he said, yeah, we did take punitive damages against some people that there was a problem with, recognized. So there is. And what are those damages? I mean, we're not talking about throwing somebody in jail, or are we talking about stand in the corner? We are just saying there might be some repercussions. Just pay attention, maybe a timeout, but please just look at what you're doing. Try to be careful. And as I was mentioned or heard before, that I was told the percentage was 30% of people that are trained, because that's how many people volunteer their time, and we understand it. So I thank you very much for my speaking just as I am, just as a citizen, your average grandmother, but someone who cares very much and very deeply and very passionately about this. And I thank you for your time.
Thank you. Do you wish to take questions from the committee?
Sure, if I have any answers.
I don't see any questions from the committee, so thank you very much for your testimony.
Okay. You're quite welcome.
Representative Guzovsky, could you get the blue sheet? I don't see any of the pink cards indicating a desire to testify. And so I will close the public hearing for HB 448, and since we're behind schedule, I will be opening up the next public hearing. I do want to say that we have two more bills that were scheduled before noon. I should read that, I guess. For HB 448, we had 4 people who wanted to express their opinion without testifying. 3 were in favor of this bill, and 1 was opposed to it. All right, we have two more bills to have public hearings on before noon, and we're behind schedule. We're gonna cover both of those before we break for lunch. Thank you. So that said, at 11:45, I am opening the public hearing for HB 626. Yeah, I suppose I should have adjourned the previous public hearing first. That's adjourned. Thank you. Yes, Representative McFarland, please begin your testimony. Thank you.
Good morning, Mr. Chairman. I will try and keep you, or get you a little bit closer back to schedule with the next 2 bills.
Thank you.
So good morning, Mr. Chairman, members of the committee. I'm Representative Donald McFarland from Orange. I thank you for the opportunity to present House Bill 626 today. This testimony represents my views and, most importantly, the views and interests of my constituents, whom I serve in the towns of Alexandria, Bristol, Bridgewater, Canaan, Dorchester, Enfield, Grafton, Groton, Hebron, and the small town that Secretary Scanlon referred to earlier, Orange. My testimony is not made on behalf of any private employer, nor should it be construed to represent the views of any of my employers. To the bill. Elections, and you should have one sheet that came around one way, one sheet that came around the other way. I have provided the chairman and the clerk with a slightly larger package of exhibits. Elections are the cornerstone of our democracy, and election security is vital to maintaining trust in that process. Computers are deeply embedded in voter registration, checklist maintenance, ballot issuance, vote counting, and reporting. To protect the public trust, these systems must not only be secure, but must also be seen as secure. New Hampshire has long been a leader in election integrity. Since 1994, we've had the first in the nation paper trail law. Last November, our historic election saw nearly 75% of eligible voters at the polls, one of the highest participation rates in the nation. And these figures reflect the public's trust in our process and the excellent work of the Secretary. This bill builds on that foundation. It allows security researchers to assess the vulnerabilities and ensures findings are transparently reported. By identifying and fixing potential flaws, we bolster public trust and prevent bad actors from exploiting weaknesses. Importantly, this is a non-partisan bill. Elections may be partisan, but the machinery that powers them must not be. This bill does not assert any current deficiencies, but instead ensures continued trust and resilience. I urge the Secretary of State's office to go further than the bill mandates, including creating a test instance of the voter registration database so that researchers may readily assess the user interfaces for town clerks, supervisors of the checklist, and so forth. Transparency and security go hand in hand, and this initiative would help to position New Hampshire as a national leader in election security. I've provided each of you with a copy of the National Association of Secretaries of State issue briefing for further context and background, and I'm happy to yield to questions and to remain available for further follow-up after public testimony.
Okay, thank you. Do we have any questions from the committee? Seeing none, thank you very much for your testimony. Oh, I'm sorry, I missed that. Representative Lurie. Oh, everyone's trying to get my attention here. Representative C, you're recognized.
Thank you, Mr. Chairman. Thank you for taking my question. Would this have anything to do with voting machines themselves?
Yeah, it's a great question, Alvin. The way that it's written, it certainly would cover those, but the main focus of this, the main thrust of this, is not on voting machines. The main thrust of this is that if a researcher is aware of a problem, We want to know about it. We want them to have an avenue to be able to report that. And I think we've had an awful lot of focus in the past in this state on our voting machines. We have that paper trail law that I talked about. So, of course, if somebody tomorrow was to identify a real security weakness in the voting machines, I'm quite sure that the Secretary would like to hear about it, and they could use this kind of a disclosure mechanism to make that disclosure. However, the thing that was most in my mind when drafting this bill was that we have had slightly less focus. We've had certainly testing performed by the Secretary's office and on their behalf by contractors, but in the public eye, we've had less focus on things like the voter registration database.
Further questions from the committee? All right. Seeing none, thank you very much for your testimony. I have no other red cards for the people to testify. Oh, wait a minute.
Mr. Chairman, I will fill out a pink card, I promise.
Okay, thank you, Mr.
Just briefly, I was interested in hearing the testimony on the bill. I think it's a good idea. The one concern that I would have is that if there are outside interests that are looking at vulnerabilities of our election systems, that there be some kind of a mechanism to allow the Secretary of State to hear those, cure them, and then make them public, so that we don't have a system that is potentially vulnerable in a public way. I think that's something that could easily be worked into the bill.
Okay, thank you for that. Will you take a question on that?
Sure.
Or Representative C.
Thank you, Mr. Chairman, and thank you, Secretary, for taking my question. In reading the bill, it looks like it should be somewhat expensive to do this, but there's no fiscal note on this bill. What's your take on that?
Deputy Secretary Hennessy just came in. She's been drafting the fiscal notes on the bills. I'm not sure if she put one together on this or not, but she'd be in a better position to comment.
Who's looking to be recognized? Sorry. Excuse me, Mr. Chairman. Go ahead.
Thank you. Thank you, Secretary Scanlon. So I just want to make sure I've got, let's call it an understanding. So your office is okay with the bill, but you would like us to add a provision about first you get to fix the problem and then disclose it. And I totally understand that, but I just want to make sure that we're on the same page. As you're fine with the concept, you want that added in.
Yeah.
Okay.
Okay, thank you. Any other questions for the Secretary? All right. Seeing none, Representative Muirhead, would you please get the blue sheet? Got the blue sheet. There is no one who wished to state an opinion and did not wish to testify, so it's blank. Thank you.
Okay. Online, there were 3 in support, 5 opposed. With that, I will close the public hearing on House Bill 626. I'll open the public hearing on House Bill 327 FN relative to filings for the office and witnessing affidavits, and recognize Representative McFarland for the purpose of introduction.
Thank you, Mr. Chairman. It looks like we're doing good. We're making up some time here. Representative McFarland from Orange, and thank you for the opportunity to present HB 327. And again, this testimony is not made on behalf of any private employer, nor should it be construed to represent the views of any of my employers. This bill addresses 2 practical challenges in the election filing process, in the filing process for candidates for elections, that have caused unnecessary confusion, delays, and expense for candidates, as well as difficulties for town officials. Under current law, candidates must file their paperwork during a limited 10 calendar day period per RSA 655.14, as we all know. In many towns, this works smoothly. But in small towns with part-time clerks, there can be unique challenges. Clerks' offices may only be open once or twice during the filing window, or not at all due to illness or other unforeseen circumstances. For candidates, this can create significant barriers to completing their filings. Additionally, there is a reasonable expectation that candidates filing in person should be able to present themselves before the town clerk or their deputy and complete their part of the process. Typically, the forms themselves are obtained from the town clerk. While this process works smoothly in many towns, problems have arisen because some town clerks and their deputies are not notaries public. When a notary is unavailable, candidates have been told their filings were complete, only later to learn that the Secretary of State's office had rejected them. These candidates are then forced to scramble to meet deadlines, take time off work, and incur additional costs to fix these issues. The challenges are not partisan. They are avoidable with minor changes to current law. House Bill 327 proposes two simple, practical solutions. Number one, for filing with the Secretary of State in towns where clerk's offices hours are limited, candidates would have the option to file directly with the Secretary of State here in Concord. This ensures all candidates have equal access to the filing process, regardless of their town's circumstances. Number two, town clerks would be able to witness affidavits without regard to whether or not they are notaries public. This streamlines the process in small towns where the clerk or his deputy is not a notary. These changes are practical and narrowly tailored to address the specific issues which have arisen, without imposing any significant new burdens on the parties involved. Filing for public office is a cornerstone of our democratic system. We have a duty to ensure that candidates for office can navigate this process fairly and effectively. These proposed changes do not alter the responsibilities of candidates or the core requirements of the process. Instead, they provide practical solutions to real barriers that have arisen under the current statutes. And importantly, this bill upholds the integrity of our election systems while ensuring access and fairness for all. I've spoken with the Secretary. To my understanding, he supports this proposal. House Bill 327 is a non-controversial, common-sense bill that promotes good governance, and I urge the committee to recommend this bill for passage and consider its suitability for the consent calendar. I welcome any questions, and I'm happy to provide further clarification. Thank you.
Thank you. I'll start off the first question and tip my hand to a question I think I'll ask the Secretary or his representative. I don't love the idea of having like 3 separate days, 18 hours. I'd rather just say you can register at your town clerk or you can register in the Secretary of State's office and just get rid of the convoluted how many hours you open, how many days you open. That will inevitably cause a headache. Would that be an issue for you as a sponsor if we just went to, yep, you can register at the Secretary of State's office or you can register your town clerk?
Yeah, it certainly wouldn't be a concern for me, Chairman. I think the reason that I put it in that way is because I do recognize that there's the potential for increased volume here in Concord, and in conversations with the Secretary, we felt that that was a very reasonable way to define the level. I think you should probably have that conversation with him.
We will, which is why I kind of backwardly asked him through you, so he knows, so he can think about it. Any other questions from the committee? Representative Bay.
Thank you, Mr. Chairman. Thank you for taking my question. Isn't it also, would you consider it a practical alternative to require town clerks to be notaries public?
It's a great question, and I figured that somebody would ask that. Let me tell you, I'm going to make reference again to my town by way of example, and this is not limited to me. I've heard similar issues from other candidates and elected officials whom we all know. But in the town of Orange that Secretary Scanlon mentioned earlier, we are a small town. We typically pay very nominal salaries or hourly rates, whatever, to our officials. And it is very hard to find people to fill those roles. For a number of years, we have had town clerks who were not thrilled about doing the job, but were happy to dedicate themselves to doing that job, and who did not have a notary public qualifications. So I think, in answer to your question, if we were to make that stipulation, just as when we make other stipulations that put additional burdens on these officials, all you are doing is causing fewer and fewer people to be willing to step forward in their local town.
Further questions from the committee? Seeing none, thank you, Representative McFarland.
Thank you.
Deputy Secretary Hennessy.
Thank you, Mr. Chair, members of the committee. My name is Erin Hennessy. I am the Deputy Secretary of State, and our office supports this bill. We currently take filings for office for any county officers, state senators, and every office above that. We do feel like this would make our office busier during the filing period. However, it's our job to process all of those filings at some point anyway. So we are happy to take on this additional the additional filings to the chair and his question about opening up to all representatives. I did have a concern about the language in the bill, normally and routinely. Just our office would have to do research for each rep that came in to file to make sure that their clerk normally and routinely was only open under the language of this law, which would be difficult because we only have access to their website and we really don't know what their normal and routine hours are. So if that could be fixed or just removed in general, that would be appreciated. I'm happy to take questions.
Questions from the committee? Yes, Representative C.
Thank you, Mr. Chairman. Thank you, Deputy Secretary, for taking my question. Do you have any concerns about a clerk or deputy clerk not being a notary?
I am not. What I can tell you is that if you require a clerk to be a notary, there's a timeline that it takes to become a notary. So if there's or if a deputy's sworn in, a new deputy is sworn in, it will take several months to become a notary, and there may be a filing period in that time in which somebody comes into their office. So I believe this is like a legislative priority versus and it's specifically for the filings and not any other option. So,
all right,
thank you.
Further questions? And I don't know if you or the secretary want to address my question, which is, can we just stop being treated like second-class citizens as state reps and file with the senators?
Mr. Chairman, I think the answer to that is yes, we can do that. And I did want to add, although I'm not advocating for a June primary, but if there happened to be one, if there happened to be a filing period in March, it would certainly be very convenient for incumbents to file in our office. Just a quick answer to Representative C's question. You have to pass a background check to become a notary. And if you don't pass, you have to get the approval from an executive counselor. So it is possible that there may be some clerks that get elected that have something in their background that could prevent them from becoming a notary.
Yes, Representative C.
Just as a follow-up on that, is there any concern that you would have about a person not being a notary? Because as I recall, when I filed, the paper wasn't notarized.
I think on those types of documents, an election official can sign in lieu of a notary. I'll have to check the statute, but
I would note that election officials are elected, so it's not like they haven't undergone some scrutiny. Any other questions from the committee? Okay, seeing none, thank you. Is there anyone else here who wishes to speak on this? Representative Guskowski, I get it? Am I getting worse as the day goes on? Yeah. I felt so good about it at the beginning. I was like, I got it. Online, there was 4 in support, 3 opposed. With that, I'm going to get this blue sheet here. Is there anybody on there, Representative? Okay, it's blank. Okay, so we are going to close the public hearing on House Bill 327. We're only running 4 minutes behind. Thank you, nobody, for opening the primary debate. About had a heart attack. We're going to reconvene at 1:05. So we'll push back 5 minutes because we're 5 minutes behind. Give everybody an hour for lunch for the purpose of House Bill 630. One quick announcement. I've put on my campaign website, which is the only website I have access to, a calendar. So you can see all of the bills, when they've been scheduled, if they've been scheduled, where they are in the process. That is what I use to track the bills. It's the same sheet, it's nothing special, but I wanted to make that available to the public. That was the only way that I could really do that. So sorry, it's on my campaign website. There's nothing else on there other than the calendar. But if you go barry4fornh.com/calendar, you can see all 75 bills. Have they been scheduled? Have they had a hearing? When it is? All there. It's not. There's no spin on it. It's just straight where we are. But that's what I use to organize. So I'll see you guys at 1:05. Okay, it's 1:05. We're gonna get going. I'm gonna open up the public hearing for the House Election Law Committee for House Bill 630 FN, preventing the dissemination of deep fake materials of political candidates before an election. Representative Corman is recognized for the purpose of introduction.
Thank you, Mr. Chairman. For those who don't know me, I'm Representative Tom Corman. I represent the Fightin' 15th, Grafton 15, which is Ward 3 of the city of Lebanon, the beautiful city of Lebanon. I need to give you some background first about myself and how I got involved in all this. I'm an emeritus professor of computer science at Dartmouth College, where I was on the faculty for 29 and a half years. And I chaired the computer science department for 6 years, from 2009 to 2015. So as department chair, I certainly had to keep my eye on what was going on throughout the entire field of computer science. But actually, I've been in computer science since 1974. And you don't need a computer to determine that's over 50 years. I have EECS, electrical engineering and computer science degrees from Princeton and from MIT. I got my master's and PhD from MIT, where I spent 8 years. I'm actually quite well known within computer science as the lead author of a textbook, Introduction to Algorithms. I say all this because I have a background in computer science. It's not in artificial intelligence, which this bill is somewhat about, and it's not in digital media. But again, I've had to keep my eye on all this, and I've been tracking all this for a long time. So last year, this committee had the bill HB 1596, which prohibits deceptive AI-generated deepfakes during elections. I co-sponsored that bill. It was sponsored by Representative Brennan. I co-sponsored it in large part because I have tracked AI since I entered grad school in 1984, so that was 41 years ago. And I didn't do research in AI, as I said, but I've seen the explosive growth in AI over the last decade. And we know that AI is capable of creating deepfakes that can easily fool many people, very easily. And the bill from last year, HB 1596, allows for injunctive relief and other relief for deceptive deepfakes within 90 days of an election. And it allows for deepfakes that are labeled as such. So if somebody creates a deepfake and says this was created with artificial intelligence, it allows somebody who distributes a deepfake unknowingly. So if you receive a deepfake, you don't know it's a deepfake, you don't suspect it is, and you send it on, you're not liable for anything. And for news stories that are about deepfakes that would show the deepfake. So if Channel 9 says, here's a story about a deepfake, and they show the deepfake, but they've made it clear that they believe this is a deepfake, that's okay. And also for satire and parody. So the sponsor and I worked with members of this committee and with the Senate to amend the bill to the point that people on both sides of the aisle were satisfied with the bill. And it has been enacted. It is currently RSA 664:14C. So that's where we are right now. Last fall, I was at a talk at Dartmouth given by Professor Hani Farid. Professor Farid is a good friend of mine, former colleague at Dartmouth for 20 years, and he's now a professor at the University of California at Berkeley. He is an expert in digital media forensics, which is determining whether media is genuine or digitally altered or digitally created. And when I say he's an expert, he might even be the world's expert. He's certainly one of the most brilliant people I've ever known. And I knew a lot of people at MIT who were just, several standard deviations above the likes of me. And he's in that category. Brilliant, brilliant man. And with the chair's permission, I'll be reading a letter from him into the record for a few minutes. You all have copies of the letter. I told Professor Farid about this bill that we'd passed and some others related to AI. And his reaction was that the bill, 1596, did not go far enough. He said it's become too easy to alter digital media without AI. So using tools such as Photoshop, a good Photoshop expert can create a pretty good deepfake that will fool a lot of people. So after this conversation, I looked more closely at HB 1596. And it defines 4 terms: synthetic media, AI, generative AI, and deepfake. Seems reasonable. But when I looked at the rest of the bill, I realized that the term synthetic media did not appear anywhere in the bill after it was defined. It wasn't used anywhere else in the bill. So the bill actually is really only about deepfakes generated with AI. So the bill before you, 630, uses the definition of synthetic media to also define synthetic media technology as any digital technology that can be used to produce synthetic media, including artificial intelligence or generative AI. So synthetic media technology can include AI behind it, but it doesn't have to. So if you think of Photoshop or even GarageBand, right, that can be synthetic media, something produced by synthetic media. So everywhere else in RSA 664-14C that mentions deepfakes produced using AI or generative AI, this bill changes it to deepfakes produced using synthetic media technology so that non-AI software is covered as well. So that's the purpose of this bill, to expand the deepfakes covered in election season to include anything produced by synthetic media technology, not just AI-based synthetic media technology. And with the chair's permission, I would like to read this letter from Professor Fareed.
I would prefer not. We have the copy of the letter. It will be a part of the public record, and the clerk has it. But we have a lot of bills, and I don't want to. How many other people? Actually, let me see that. How many other people are signed up for this? Just one. Actually, it's fine. Just one other person signed up, so not a big deal. It's not gonna. If it was gonna throw us off, I would say no. But you're fine.
Thank you. So this is from Professor Fareed, dated January 25th. I write in support of HB 630FN. I have read this bill and I agree with the sponsor that it strengthens HB 1596 from 2024 in an important way. For background, I have been conducting research in digital media forensics since 1999 with over 200 peer-reviewed publications in the field. I'm frequently called upon as an expert witness in cases in which the veracity of digital media is at question. I have testified many times before the U.S. Senate, U.S. House, EU Parliament, and UK Parliament on issues of digital media integrity and appropriate regulatory interventions. I was on the faculty at Dartmouth College for 20 years, which is where I met Representative, then Professor Corman, and I've been on the faculty at the University of California, Berkeley since 2019. HB 1596 prohibited deceptive deepfakes within 90 days of an election, but it prohibited only deepfakes generated by artificial intelligence. This is an overly and unnecessarily narrow definition of deepfakes that does not contend with the reality of today's landscape of manipulated and malicious content. Digital media technology has evolved to the point that many users can create convincing fake media that are so realistic that determining that they are specifically generated with AI technologies is challenging and requires highly specialized software. In addition, there are many ways for creating misleading or malicious content that does not require the use of AI. Precautions against election interference should focus on the malicious content and not on the specific mechanism or technique used to create that content. HB 630FN recognizes these realities by defining synthetic media technology to include any digital technology that can produce synthetic media, and by prohibiting deceptive deepfakes created by synthetic media technology during election season. Instances of deepfakes in the public sphere abound both domestically and internationally, and as you know in New Hampshire, deepfakes have already found their way into elections. By expanding the scope of deepfakes to include all synthetic media, HB 630FN will provide additional safeguards in elections. Signed, Hani Fareed, Professor, UC Berkeley. And with that, I am happy to take questions.
Okay, other questions from the committee? Yes, Representative Wood.
Thank you, Mr. Chairman, and thank you for taking my question. I definitely on the same page. I didn't understand when they focused this bill on AI versus the other techniques out there. Why does this bill even necessary? To me, digitally, I can create illusions even without using the person's voice or features just by using the media out there saying that he said this, showing examples of other people saying this. There's so many ways to create an illusion. I think this bill missed all of that stuff. I think most of this is already covered if you're smart enough to find these things or willing to find these things. But just because we got some technology that makes it easier doesn't mean that this hasn't been done for years. And is covered already in election law as far as I understand, as long as you can prove it. You got the same problem here. Why is this, sorry to be, this is more my opinion than yours. I apologize to the board. Yes, thank you. I'm amazed you let me go that long. Thank you, Mr. Chairman. Yeah, got it. How do you think it's different? Sorry. How do you think it's different than what I just said? Thank you.
All right, thank you for the question. What the bill from last year did was it focused on synthetic media generated by AI. And it didn't cover any other synthetic media. So if you were really good with, I don't know, GarageBand, you could take clips of me talking and just make it sound like I'm saying something I've never said. Or if you're really good with Photoshop, you could create an image of me robbing a bank, which I have not done. And allegedly, I have allegedly not done. And what this bill does is it just says, all right, if you're using other software, other digital media software to create it, then that would be covered under this bill. I mean, you're right that these things could be done, and what we're trying to do is cover them under the law. As far as whether that's already covered under election law, you know, you're the election law committee. I hope you know the laws. I'm in science, tech, and energy. I know the energy laws. So I'll have to leave it to you whether it's already covered. The one thing I would say then is, what was the part about AI already covered? Why did we need that bill?
I love
Thank
the
you.
judge answering the question with the question. It's one of my favorite things to do. Representative Weary.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Just so in I don't know if you have your bill in front of you.
I do.
But so under synthetic media in 1A, it talks about other digital technology. Would that, but there it's talking about the media being created. So it implies that digital technology, I'm loath to add definitions if we can avoid that, and is there any specific justification for a deep fake down in line 23 as opposed to just a message that a synthetic media message, something along those lines? I'm just cautious about trying to find a point on this. So do you think digital technology is included in this initial definition?
In the initial definition
Of synthetic media. So it talks about adversarial network techniques.
yes,
or other
it
digital-
is included in the original definition of synthetic media. However, as I mentioned, when I read the bill, when I read 1596 from last year, although synthetic media is defined, it isn't used anywhere else in the bill. So, it's just a dead-end definition. So my main purpose with this bill was to actually incorporate the notion of synthetic media into what would be covered. And the places where the original bill and the current law say message, I suggested that it should say deepfake, because a deepfake means that you're creating media that shows somebody doing or saying something that they didn't do or say.
Okay, but you got to get to
Very
the question quickly
very-
on this one.
So,
'Cause it's,
so would you have any objections if we just said instead of message, we said synthetic media, and then instead of artificial intelligence or generative AI, if we just said digital technology?
I don't know that I would object. I don't see where that provides an advantage over what is in the bill.
Okay.
all
Thank
right.
you.
Any further questions? Seeing none, thank you.
Thank you.
Only one other person signed up to speak, Olivia Zink from Open Democracy.
Good afternoon, Chairman and members of the committee. For the record, my name is Olivia Zink, Executive Director at Open Democracy. I live in Franklin, and I'm testifying in support of House Bill 630. As technology rapidly advances, artificial intelligence and deep fake are becoming more pervasive in our society. On my phone, I have a voicemail that I was left before the primary on my home voicemail, and it doesn't have a disclosure of who paid for it. So this bill, what it does is just requires disclosure of anything that's created using this. It doesn't prohibit people from doing it; it just requires disclosure. And we support adding these definitions because of photos, videos, audio recorders could mimic anything to be more accurate and believable. Could you imagine if you lost election because somebody said you were saying something? So say we said Chairman Barry likes Mars bars. I have no idea if you like that kind of candy bar or not. But people could make up whatever message they want and distribute it and say, don't vote for this candidate because of any reason. And so I think I want to thank this committee for working really hard in a bipartisan way to pass a bill such as this. And this bill just strengthens the work that was done last year as technology evolves. So we urge you to support moving this bill forward, and happy to take any questions.
Other questions from the committee? Seeing none, thank you. All right, is there anyone else present who wishes to speak to this bill? I don't see any. Thank you. We have the blue sheet. It's blank. Online, there were 36 in support, 0 opposed. The committee, I'm going to close the public hearing on House Bill 630. The committee will stand in recess for 8 minutes until 1:30 for the introduction of a new bill. Thank you.
It's an amazing website. And find the calendar.
Oh, not, so get to type it in. Literally just type in calendar. You don't need to request, I don't think you're going to request a yard.
Well, I did request a billboard.
Okay. If I have it,
Something with a picture, maybe. I'm not going to throw anything at them.
AI generated?
AI generated picture, of course.
We're not doing a hearing right now. They just gave us all the fiscal notes. So instead of passing this stack of stacks, what I'm going to do is I'm just going to lay them out on the center table here, and you can come and get them at your leisure, because otherwise you're going to be Yeah, not fun. So I'm gonna do that, and we got another 5 minutes. So. Okay, it's 1:30. We're going to open up the House election law public hearing for House Bill 474, requiring a second witness at the counting of write-in votes. And Representative Burnham is recognized for introduction of the bill, and I guess I will take some notes. I didn't equate that. Ready.
I'll be back. Yes. Thank you, Mr. Chairman, and thank you, committee members. I'm Representative Claudine Burnham, and I'm in support, obviously, of HB 474, which is just a simple line requiring second witness at the counting of write-in votes. This bill closes the gap in bipartisan write-in and overvote determination. Currently, when a person writes in a vote, the moderator is given the authority to look at the screen and determine the vote's intention and adjudicate the ballot without a second set of eyes. By correcting this gap, this will allow for a bipartisan review to be done. The second witness must be either a selectman or a town clerk, per the New Hampshire Constitution. Please vote ought to pass to help close this gap and be sure our write-in votes are approved by counted fairly. Thank you.
Okay, and will you be taking questions?
Sure.
All right. Are there questions from the committee? Representative Grill, we haven't heard from you today.
Hi, my question is for nonpartisan elections and offices that are elected on a nonpartisan basis, how would that party registration be determined? Sorry, that was probably confusing wording, I guess.
Like for the local elections, is that what you're pertaining to, like school board or?
Yeah, I guess I'm just a little confused of if that would be in effect for all elections, only the partisan ones. And a lot of times these offices are elected without party registration, so you could get, for example, a slate of all Republican moderators, clerks, or another town all Democrat moderators and clerks. I guess, how would that person be selected in those instances?
Well, I believe that there are some towns that are bipartisan, so I think it should just be consistent all the way around. And it just kind of shows a balance to the system by choosing it that way.
Okay.
Doing double duty here. Representative C.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. This sort of follows on Representative Grill's question. What happens if the moderator is registered as an independent? Who would be the opposite party?
Well, that's a good question. I would just assume that it would be a different party member. Doesn't necessarily mean one of the, as long as it's somebody different and not another independent. Maybe that's not clear.
I was just trying to figure out what you intended.
I got to ask for a follow-up there. They spoke with us about that at the chairs meeting this morning. Further questions? Okay, seeing none, thank you, Representative Burnham, and I'm going to email you my very short notes.
Thank you.
Next up is Brody DeShays with the New Hampshire Municipal Association. Welcome to election law.
Thank you, Mr. Chairman. Thank you to the committee for taking my testimony. So the New Hampshire the New Hampshire Municipal Association is opposed to House Bill 474. The addition of the last sentence is a little bit confusing for us to try to interpret. Our current interpretation is that this is implying that folks who are moderators inherently have that they've declared a party, and that therefore they would have to find someone else of the opposing party. There can be sometimes multiple opposing parties in a state. Right now, though, the two recognized parties are Republican and Democratic. So I guess the assumption would be if you're a Republican, you need to find a Democrat. If you are a Democrat, then you need to find a Republican to partake in the process of reviewing the write-in votes. Our concern is the burden, the vagueness, and how that is done. It's not really entirely spelled out how exactly a moderator would appoint someone. Would they swear them in as if they were an assistant moderator? Those are things that need to happen during the election process. Those who are working are sworn in by the town clerk or by the moderator. prior to the election day beginning. Aside from the additional burden, moderators are elected and trusted. There's a reason why it's a nonpartisan office, why people of all parties serve in it. The voters, they elect their moderators, and they trust their moderators, or another moderator would run and the voters would replace an existing moderator if they had a problem with the way that they were conducting their business and running the election of a community, whether it was a local election or a state election. Additionally, I just want to flag that there are party poll watchers. And this is a very public process in the state of New Hampshire. So if you are a Republican and you have a problem and believe that you'd like to watch the process closely, you can. And vote challenges can happen too. So the moderator has to do all this publicly. It's subjected to public scrutiny, and either party that's on the ballot is allowed to appoint poll watchers at the polling place. So for those reasons, and because of these additional burdens, we are currently opposed to House Bill 474, and I'd be happy to take any questions if you have any. Thank you.
Are there questions from the committee? Seeing, Representative Singh.
Thank you, Mr. Chairman. Thank you for taking my question. Would it be helpful if the town could grab an extra computer monitor and plug it in so that more people can see another screen, especially if it's a larger screen?
I don't know what this. Thank you for the question, Representative. I don't know what the size of the screen is, and I'm not entirely sure what different moderators do specifically currently at their different, their election, their polling places, to ensure public scrutiny of the process. But I'd be hard pressed that a moderator wouldn't let a poll watcher or someone who's like a ballot clerk be able to watch that process. Typically, the write-in votes are counted by ballot clerks. At the end, they count all the different, how many write-ins there were, and make sure everything adds up. So in the moderators, it's their job to interpret a write-in vote, what the intent of that vote was, who the vote was for. So we've seen a rise of people writing in votes for candidates who are already on the ballot because they would like to force a hand count vote for those ballots. And usually it's the moderators going through the write-ins of candidates that are already on the ballot and basically saying, yep, that vote does count indeed for this candidate that's on the ballot, even though it was a write-in, and making sure that everyone's vote is counted during the process.
Follow up?
Absolutely.
As I understand it, the computer that comes with the voting machine, at least for the Voting Works machine, is just a small laptop. So it's kind of hard to crowd a bunch of people around and look over the shoulder of the moderator while he's doing that.
Okay. Thank you, Representative.
Further questions from the committee? Representative Gilmore.
Thank you. As a moderator, and who's 12 years now, I always assign my ballot clerks to do the counting of the write-in votes. So our machine doesn't have that digital process. Hopefully next time it will. So we have to do it by hand. So do I understand this bill to say that now I have to have all those write-in people would have to have a member of the other party? I don't even know the party of my poll workers. I don't know. I'm sorry. I guess I'm really just talking. Sorry, but is that your understanding too? Or?
There you go.
The
first one's free.
Yeah, I was gonna. This specifically cites ballot counting device. So I would assume it would only account in those situations where a municipality is using a ballot counting device. That would be my interpretation.
It says printed.
Yeah, Representative Gilmore, you got to ask for a follow-up.
I'm sorry.
It's all right.
I'm sorry, Mr. Chairman.
I'm not the one who cares about that thing, but
I understand. You're right.
I've been talked to.
I'm good.
He's good.
Okay. Any other questions from the committee? All right. Thank you. I'm sorry, Representative Hennessy. Normally I let you go second. Your car got buried. I apologize. So you're up. You should have been second. I apologize.
Good afternoon, everyone. Erin Hennessy. I'm the Deputy Secretary of State. So the legislation before you strictly applies to the electronic ballot counting devices that digitally display or print write-ins. Right now in the state, we only have one device that does this. This is the Voting Works device. In March, it'll be in It grows every day. I want to say 40 polling places at March town elections. That's just an estimate right now. And in the training process for moderators and anyone who learns about the Voting Works device, we train that when they do the adjudication process of the write-ins, which does come up on a laptop screen, as Representative C did mention, that they are to do that in pairs. So once someone does the typing and someone confirms that what was typed is what was written on the screen. This is very similar to the process that is used for paper ballots when they look at a write-in, where there's two people working together. They're not done in silos where just one person calculates the total write-ins. So it's a team process. I am not opposed to putting in law that it be a team process. However, the moderator is a nonpartisan elected official. And as it has been mentioned, does not run as a member of a party. They may be an undeclared voter. And so the term opposing party would be difficult in a lot of situations and also politicize the moderator, which we don't want to see in an election. So I would just recommend some language changes there. But in regards to having two people do it, we do currently train to that. The moderator does have the ability to assign this to someone else. So it's not necessarily the moderator who is typing in on the computer. It may be one of her or his assistants doing this. So I just want to make it clear, it's not always the moderator doing it. They are a nonpartisan election official, and we currently do train to this.
Will you be taking questions?
I'm happy to take questions.
Okay. Are there, Representative Gilmore, preemptive, you want to turn your mic off for?
Oh, thank you.
Yeah, because things happen. Questions from the committee for the Deputy Secretary? Representative Weir, you look intrigued.
Thank you, Mr. Chair. Thank you, Deputy Secretary, for taking my question. So there is a paragraph in 659-63 about counting to be public. Perhaps 659-64A could be amended to convey that the counting of these write-in votes should follow the principles outlined in 659-63, although it may be implied, I'm not sure, but
We gotta get to the question, Representative.
yes, is that, would you see, do you see this counting in 659-64A consistent with the counting to be public within 659-63? I think that would be actually the appropriate question.
Thank you for the question, Representative. I didn't bring my law book, so if you are seeing that that is the exact statute where it requires public counting, then yes, they would. This already has to be done in public.
Okay, thank you.
Further questions from the committee? Seeing none, thank you.
Thank you.
I don't believe I have any more pink cards. Representative Guskowski. I'm getting worse. I'm trying. I'm trying real hard.
Just be consistent.
Yeah. Yeah, I should just let it fly, or I could just butcher it in a way that's just not even close. Representative Smith. There was no one signed up who did not speak. Online, where did it go? Online, there were 4 in support, 6 in opposition, and with that, I will close the public hearing on House Bill 474. We've got 5 minutes, so I would like to. We're not going to take a vote, but I would like to go into executive section for the purpose of discussing. Where is it? 327, which we heard earlier today. That's the one about signing up at the Secretary of State's office. I'd just like to get the committee's feel on it. We're not taking a vote, but so I'm going to open up the executive session for House Bill 327 FN relative to fine for officer and witnessing affidavits. Does anybody have any comments on this? I think I made my position pretty clear, which is I think anyone should be able to do this for state rep. Does anybody else have any concerns? I'll bring that amendment forward when we actually exec it, but does anybody else have any comments on that? Representative C.
I kind of agree with the idea of just saying the Secretary of State's office can take these at any time, regardless of whether the town clerk has limited hours.
Okay. Any other questions, comments? Representative Quayle, I almost blanked on your name. Vice Chair.
I agree with Representative C.
Okay. Any other questions, comments, Representative Gilmore?
Having been to Orange 4 times, and 3 times there was different clerks, and another time there was nobody. And yeah, I think it's a great bill.
Okay. Any other questions, comments, concerns? All right. With that, I'll close. I just wanted to hear from the committee. So with that, I'll close the executive session on 3:27. I guess I'm technically recessing it, so recessing the executive session for it. Anything else we want to talk about? Oh, let's talk about, while we have a second, I'm going to open up the executive session for House Bill 626, directing the Secretary of State to implement a vulnerability disclosure program for certain electronic systems. I believe I have in my notes that the Secretary was in support. Yeah, he's in support of the idea, but he wants a provision about if a problem is discovered, they're able to fix it first, which seems very reasonable to me if the Secretary of State's in support of it. I think the Secretary's concern is very reasonable, which is, hey, if we do this and we find something, we probably shouldn't tell people before we fix it. So I think that's actually pretty reasonable. Does anybody have any comments about that they'd like to opine on? Yes, Representative Toner.
I agree with that. The only time or the question that I would have with that is if there's any type of breach that happens. There is RSAs associated with publicly announcing breaches, so I don't know if that would conflict with that or not. It might not.
Yeah, that's an interesting point. Public breaches. Okay. Any other questions, comments, concerns on this? Okay. Representative Toner, do you think you can look into that? With that, I have no clue about that RSA, so I anything I say is conjecture. So
Yeah, I'd be happy to. And I can send it to you, but it might need a review by the Secretary of State's
yeah,
office.
that's fine. Yeah, it's not an early bill. So okay. Anyone else wish to opine on that? I just want to kind of get where people's heads was at. So that's fine. I'll recess the executive session for House Bill 626. Thanks for indulging me there. We definitely don't have time to begin discussing the signs on property. That'll take God knows how long. So we won't start that discussion until we hear the next bill because we have 2 minutes. So we won't. Everyone in this room is going to have a different standard for what that's going to be. So that'll be interesting to watch that sort. All right. I'll see you guys in basically, I don't know, 60 seconds. All right, it's 1:50. So we're going to open up the House Election Law public hearing for House Bill 389, requiring candidates to attest that they have spent not more than $1,000 in an election, and we will recognize an alumnus of the committee. Representative Howard, it's good to see you.
Thank you so much, Honorable Mr. Chair and committee members. It's good to be back. I'm Representative Heath Howard. I represent the towns of Stratford and Barrington in Stratford District 4. Today I'm introducing HB 389, and it's a pretty simple bill. It requires anybody who doesn't spend or receive $1,000 in an election period to still file. The thing is in 2022, we had 418 out of 893 state representative candidates who did not file a single report. That's 47% of everybody who ran. And we had 9 out of 65 Senate candidates. That's 14%. So we had a significant amount of people who didn't submit any sort of financial disclosure. The thing is that right now, because of the way that our paper filing works, you don't necessarily need to file a paper report, but if you go on to the online system instead, you have to file everything sequentially, meaning that you have to check off a little checkbox that says that you attest that you did not spend or receive over $1,000 in that period. This would just make sure that the process is the same. It would ensure compliance across the board, make sure that every single candidate is just checking off a little box if they didn't receive that or spend $1,000. That being said, because it's a fairly simple bill, I'm open to any questions. Thank you.
Questions from the committee? Oh, that was easy. Okay. Thank you, Representative Howard.
Thank you.
I thought at least somebody would ask a question, so let's go through here. Deputy Secretary Hennessy.
Thank you, Mr. Chair. Good afternoon, everyone. I will leave it to the committee whether you think this is a good idea or not, but I just want to talk about a few technical aspects of the bill. First of all, our system is capable of doing that, so that's good. There's not a huge fiscal note attached to this. As the representative said, these are already in the system. They're called no activity reports. One thing I just do want to point out is that the language in lines 14 through 15 is repeated language that's already mentioned above. So I would just say pick or choose where you would want that language, but just say it once for just to clarify for our office. Also, we would look for clarification about the language on expenditures. So on line 8, it says candidates whose expenditures do not exceed $1,000. However, on the preceding lines, they are receipts or expenditures. So if you're just looking for expenditures, I would say that it might be a little confusing to those candidates if they're supposed to file receipts or expenditures or one or the other or for both. I believe this language was changed in HB 1091 that came out of this committee last year, that it required receipts or expenditures. Happy to take questions.
Okay, questions from the committee? Okay, seeing none, thank you. Next up is Kaylee Estrat. I did it earlier today. Well, you'll hear in a second.
Hi, thank you, Chairman and members of the committee. My name is Kaylee Abstradio, but today I am going to be representing Bob Perry, a former member of this committee, and also he serves on the board of Open Democracy, which is a nonprofit. So he says, I am out of state. Please do not construe my non-appearance as a lack of interest in the bill, first and foremost. My experience while serving on the Election Law Committee years ago informs me that describing any bill as simple is folly. However, I'm willing to say the intent behind the bill is a simple one. It is to minimize the cynicism and speculation over why such a high percentage of candidates do not file financial reports as required by statute. I'm aware that as of December 16, 2024, 313 House candidates did not file financial reports for the 2024 election, nor did 6 Senate candidates, 1 Executive Council candidate, and it is reasonable to ask why. While I strongly disagree with the SCOTUS decision and Citizens United, I strongly agree with its observation that disclosure of political spending is crucial to the public interest and in the preservation of democracy. Indeed, courts since Buckley have upheld the legality and importance of transparency in the political realm. The bill will require the placement of a checkbox to be added to the existing reporting forms, both online and handwritten, by which candidates would affirm that their spending was under the applicable threshold during each reporting period. This affirmation would negate the reasonable skepticism and concerns over why such a high percentage of reports are not being filed. Is it really because they are exempt from filing, or is it an intentional disregard for the law, an attempt to hide, or other various considerations? The Supreme Court gave us a few wild checks on Wild West political spending, other than to allow spending to be disclosed. With the stakes as high as they are, the unprecedented amounts of money flowing into presidential and even local elections, it becomes more important each election cycle that candidates explain why detailed reports are not required of them. A simple check of the box provides the public with a degree of confidence the law is being followed. I urge OTP on HB 389. Thank you.
And are you taking questions? Are you speaking for Bob Perry, or are you just no?
Sure, if there are.
All right, go for it. I love that. Let's go. All right. How's it going? Because it's cold here.
Probably good.
Questions from the committee? All right, thank you. Next up, or last up, is Olivia Zink, Representative Gusovsky. Yes. Can you grab the blue sheet?
Good afternoon, members of the committee. For the record, Olivia Zink, Executive Director at Open Democracy, and I'm a voter in Franklin. I think the best way to describe how this bill works is show and tell. So when you file online, there's this box here that says no activity report. There's been no activity on my campaigns. If you file using the paper form, there is no said box. So the forms are different based on how you file. And I just want to point that out because I think it's important that however we report, it's consistent based on which way you report. I know that this problem will be solved once everybody files online, which hopefully will happen at some point. The other thing that I just want to mention that hasn't been mentioned is that I do think that this efficiency will help the Attorney General when they're investigating who has filed campaign finance reports. Right now, we don't know. Is it because candidates didn't file, or is it because they didn't report? So I think that's really important to make sure that there is greater transparency in our campaign finance. I urge ought to pass on House Bill 389. And the other thing that I would just clarify is that if you are amending the language, I think it would be good to just, instead of saying there's been no activity since my previous report, I'm under the threshold for reporting. Might be clearer language too. Thank you.
All right. Will you be taking questions?
Happy to.
Okay. Are there questions from the committee? Seeing none, thank you. I don't have anyone else signed up to speak or no other pink cards. Is there anyone else present, excuse me, who wishes to speak? I thought that was going to take a lot longer. This is my first big scheduling mess up for the day. I thought that one was going to take a lot longer. So we will close the public hearing on House Bill 589. 389, excuse me. There was one person signed up who didn't speak. Mo Baxley, are you still here? Did they leave? Okay, they wrote something after it. I can't read it. And then 389 online had 20 in support, 1 in opposition. With that, I'll close the public hearing. We'll hang out here because I'm going to look through these bills again and see if there's anything else we can discuss. But otherwise, we don't have another public hearing until 2:20. So give me 1 minute to go over the bills in our possession that we've had hearings on. Okay, actually, all right.
Thank you.
So since I did mess up and we do have 20 minutes to kill, excuse me. Since we do have 20 minutes, let's begin the discussion on the political advertising bills. The ones on public property. So I'll open up the executive session for House Bill. Let's start with House Bill 336. Relative to the placement of political advertisement on public right-of-ways. Does everybody have a second to go recover that bill? get it up here on my screen. We're on House Bill 336. Okay, so we're on discussion on the bill. Does anybody want to do the opening salvo on this? Because I know this one's gonna. I think this might be one of those weird bills that may not be partisan and may actually divide both caucuses. I don't know. I could be wrong. Does anybody have any thoughts they want to lead with? Okay. Representative Muirhead, thank you for saving me from the awkward silence. Can you turn on your microphone, though?
This is just kind of a grammatical thing, but in the sentences that are being added, which are lines 4 through 7, the first clause says, well, unless permission is granted by this or that, the political subdivision or the owner. And just logically, that means that if either one grants permission, that's sufficient. And then the next sentence says, no advertising shall be placed without the owner's consent. And that means that the first sentence should probably say and, or just be grammatically clarified so that, first you need the political subdivision's approval, or maybe you don't need that at all, I don't know. And then second, you need the owner's consent regardless. So that or is just a misplaced conjunction, I would say.
I would
not to be picky.
No, I think it's actually fair. I think you can strike that granted by the political subdivision because the land is, when you're talking about a public right-of-way over private land, the land is still owned by the private individual. The public just has a right to pass over it. So I don't think you would actually, I personally wouldn't believe that you would need the political subdivisions, as long as you're not obstructing the right-of-way, right? So long as you're not blocking it or blocking a sight line, I don't think you would actually need it, nor do I think it would be appropriate. And I definitely agree that it's confusing. And you definitely shouldn't have the situation where the political subdivision is somehow saying, yes, you can put signs on this right of way, and the property owner is like, no, you can't, it's my land. So I tend to agree. I think you could just strike that. I think you can just strike that by the political subdivision. And just kind of as a history of this bill, the sponsors did approach me. I am a co-sponsor, but they approached me with the concept. And I think originally they were trying to do it to where you could place political signs on all public property. And I said, I'm not into the free for all. And I think this is kind of what they came to as an attempt to meet in the middle. So for whatever that's worth, but I think I agree with that. I definitely don't think that the granted by the political subdivision is relevant. Representative Newsom?
With that change that you just mentioned, isn't that what the status quo bill existing already is?
Yeah, I think, and that's where I was headed next with that.
Okay, thanks.
Because that's not what they were originally trying to do. So our laws about putting signs on public property are contradictory. There's one section that says you can't do it, and then there's a section about going around and picking up signs set on public property and who can do it. So it's like you have a section that says you can't put the signs up at all, and then you have a section that says, hey, but here's who can pick up the signs that shouldn't be on the property. So you raised, that's where I was trying to go with, is they were trying to get to the underlying question of should you be able to put signs on public property, to what extent, and how do you regulate it? And it kind of got, I think, muddled in the OLS back and forth. And we have two bills about this subject, obviously, which is why I put them together, and that's why we got 20 minutes. We can hash it out now about what we think. Representative C?
I was just wondering if it'd be nitpicking to worry about whether the town owns the street or whether it happens to be just a right-of-way over private property. My house, the town owns the street, so I actually have to mow grass on the town's property.
Send that town up there to do that, or yeah, this is one of those things where I don't even know how you'd have to write for every possible scenario. Representative Quayle?
Yes, thank you, Mr. Chairman. I had the same reading of that sentence that Representative Muirhead mentioned. It does appear to give a political subdivision authority to grant permission to a piece of private property that's under a public right-of-way. And it had the exact same concern. I think it could be addressed by removing that first clause, unless permission is granted by the subdivision, or just strike that out directly, in which case no political advertising shall be placed on or affixed to any public property Unless, let's see. I'm trying to edit in my head as we're talking, but basically what I'm trying to get across is that public property is owned by the political subdivision. Right?
Maybe it could be state, could be fed, could be county.
Okay, no political advertising shall be placed on or affixed to any public property owned by a political subdivision except by permission of the property owner. That doesn't address.
Yeah, I think it's even more. But so I think the question at hand.
The or doesn't belong there. Is basically.
Yeah. Oh yeah. The language clunky.
Doesn't
Yeah.
belong
There's
there.
no. Yeah. There's no debating that the language is clunky. The question I hand, the reason these two bills are put together is, I think we should address the issue, the underlying issue, which is where can candidates put signs on public property? I would venture to say that everyone in this room would agree that you can't put a political sign on someone else's private property without their permission. I would venture to say everybody's on the same page there, right? So the question is how do we handle signs on public property? And that I do think there would be a differing view. And once again, I don't think it's partisan. I think there'd just be different views in all. Personally, I don't believe signs belong on public property at all. I just don't like them. I don't want to see signs on public property at all. I don't think they belong. I think it's lazy campaigning, and quite honestly, it just makes the state look trashy, in my opinion. If you want to put a sign up on your own property, that is your First Amendment right that I will defend to the end. But it's where do you draw the line, right? So if I go put a sign out on the highway, right, and it's on state right of way, which is what on state property. Let's just say the state owns the highway. It's on the state highway land, and if I could do that, no one's going to lose their mind. If I go and I litter the front lawn of town hall with Barry and the chicken sign, people are going to be mad. Either way, there's a sign on public property, right? And I guess my contention is how do you adjudicate in policy when one is okay and when one is not okay? So I kind of want to hear what people's thoughts are. Like, when is it okay to do this? I've already taken the position of I'd rather just not. But when is it okay to do it? In what situation isn't okay? And then the next bill following up this is, what are the abutters' rights to that? You can raise issue with Representative Weiler's bill about the mechanics of it. The underlying point is if you're an abutter and it's technically state right of way or land or whatever you want to call it, and somebody puts a sign up there and it's legal, illegal, whatever you want to call it, but it looks like it's yours. Like, I think there's a legitimate concern there. But once again, there's a gray area, right? If it's in the middle, like he's talking about, if it's in the middle of the triangle in the middle of the road, nobody cares. If it's next to your land and implies that you're doing it, I can see why you'd be upset. So anyways, what are other people's thoughts about the placement of these political signs on public property? That's where I need to get to. Like, where are we at on that? Representative Toner.
I mean, my ultimate opinion would be basically like the parallels with you that I don't want to see, like, if there's like a public common or a park, I don't want to see it littered with political signs at any time. So I parallel. The only question I would have is that, like, the day of the elections, like in our town, they have a designated area at the high school which is technically public land that we could place signs for that day. And I don't know how that would play into this.
Yeah. So there was conversation when I was discussing this bill with the sponsors. I told them I didn't have an objection if a town passed an ordinance saying you could put signs here or here, right? There were people that wanted the default to be you can put signs wherever you want in the town, and the town can ban where you can't put it. And I said, no, that's free for all. But I'd be okay with that if the town passes an ordinance that says you can put signs here during election. This is the electioneering zone for signs. You can put it here during this time. I'm totally cool with that. If there's a vote by a public body and they can rescind it, I'm totally fine. But I personally don't want the default to be yes. I think the default should be no unless the town says yes. That's my personal opinion. Representative Grill.
Yeah, I think I'm on the same page. Maybe we could include language that specifies the towns could vote for special electioneering sections of town or whatever. But I think this does a good job addressing the gray area between, parts of town that might look like public property might be adjacent to a highway or a major road. And I think I'd also agree that we should defer to the owner of the land, and I'd be fine with striking the political subdivision part of that as well, because I think that makes it, again, more deferential to the property owner who has to look at the signs on their property or near their property every day, and also prevents it from being a free-for-all and everyone just putting their signs up 93 North and mucking that up. So I think that would be good, and we could include the language on town-specific ordinances as well.
Representative Bay, I think I saw your hand.
Thank you, Mr. Chairman. I'm going to mark this on my calendar because I totally agree with you on no signs on public properties. I just want to mention that.
Representative Wood.
I won't be as nice. I think this is way too complicated. I love the signs. I love the fight. It is one of the best parts of running. We have signs on public property. We have signs taken off public property. Go to the town. They passed. They said couldn't put them here. We could put them there. All the towns are so different. There are areas. I mean, people want to run. They want to know what they are. There's a contradiction. I deal with people all the time. But not another sign. Everybody recognizes our sign throughout the state. Not another sign. I said, well, you don't want to know who's running? So it's a contradiction here, but it's a fun contradiction to play with when you're running. You're getting people upset. You're getting some people to like you. It's just part of the game. We're going to go over there. Now, every public place in my town, I can't put a sign. That's ridiculous. There's a lot of public places that really don't even belong to the town. Who the heck knows how it owns? We find when people are upset, we move them. It's that easy. And some people move them for us.
That's I believe that's a crime. I believe that is a crime. You can do some jail time for that. Anyways, Representative Harley Bolia.
Yeah, thank you very much. Real quick. Yeah, I have to agree with the chair by and large. I'm sorry, but when it comes to primaries where you have about 15 candidates at the top of the ticket, guess who gets to remove all those signs that are left behind? Because it's not usually the candidates that come by and pick them up. It's the people in the town of that party have to go and do all the cleanup. So yeah, it's a big trashy problem. I agree. I'm fine with buttoning it up, and I don't really understand. I'll have to look up. But if somebody puts a sign on your property, that's not a crime to remove it, right?
No, it's not. If it's on your property, no, it's
Okay.
not. No, it's explicitly allowed. Yeah. Other people. I told you guys this wasn't going to be partisan. I told you this was one of those weird ones that'll cut different ways. Any other comments? Anybody else? Yes, Person Wilhelm. I'm excited. How does the north end of Manchester feel about signs on public property?
Well, it's a great question. I appreciate you asking, Chairman. I think I have not yet polled my constituents specifically on this. However, listening to you talk about the solution of saying, hey, let's defer to the municipalities. Let's say if you pass in public session, some sort of during this time period or this particular space, signs can go up, but otherwise across the board, they should be banned. I think that makes a ton of sense. And would love to work with you on crafting an amendment.
I would love to do that. A Barry Wilhelm election law amendment would blow a lot of minds. I'll ask a follow-up to that one, if I may. What do we do about state property?
I think Representative Muirhead has some ideas.
I hate the following words. I swore would never pass my lips this session, but I'm going to let them. Interim study.
Oh God, no. I refuse. Look, no one here wants to do that. I think that's the next, because it's right. It's complicated, right? Because you have municipal, you have county. People forget county. I represent Goffstown. I've got county property, county, state, and then feds, which I think it's banned on the federal property. But Representative Toner.
Thank you. I just wanted to add, because it was thrown around, putting signs on the interstate and stuff like that. It's illegal.
Sort of.
23673.
236. That's not an election law
73.
statute.
Yeah, it's in, because I worked in the DOT. Yeah, it's transportation.
you can't-
On federal highways and federal, like, and that's federal land and the turnpikes, it's illegal to put signs in any of the medians, any of the exit ramps going up. Basically, there's fences of very large right of way in the interstates systems, and it's illegal to do it.
So I'm gonna blow your mind here. You ready? Political advertising may be placed on state-owned rights of way as long as the advertisement does not obstruct the safe flow of traffic, and the advertising is placed with the consent of the landowner in the right of way. So that's when they're talking about, I think, highways. They're talking about you can do it. It's definitely it conflicts. I'm with you. Like, that's part of the problem with this subject is it literally conflicts with itself. Like the election law conflicts with itself, much less with the transportation statute you decided. Like it definitely, it's like our campaign finance laws, which are say one thing, and we have a bill where it's like one and immediately the other. So, but yes, I will have to. Once again, like it's not just state right away on highways and stuff like that. It's state property in general. Like I'm asking the question of what about state property in general? Because the municipalities right now don't have the authority to control the state property at all in any way, right? So that's why I asked that question is state parks, right? State parks. Representative Quayle.
Maybe modify that sentence, no political advertising shall be placed on or affixed to any public property, including highway rights of way, unless permission is granted by the owner of that property, period. Because every piece of property in our system has an owner, whether it's an individual or a governmental organization or some other kind of organization.
Yeah.
So that, I think, would clear up the confusion at least.
Yeah, that would probably clear up the confusion, but it doesn't answer the underlying problem of what should be allowed.
Well, that would be, in this case, that would be up to the owner of the property, whether it's the state or the political subdivision. As far as your point about objecting to signs, personally, I'm with Representative Wood. I don't object to the display of colorful display of political fervor. But I think that would make it clear and unambiguous if we made a change as I just suggested.
Representative Muirhead.
I mean, if Chairman Barry's photo were on the sign, would you object to that, Representative Quayle?
That's an entirely separate issue.
I put a literal chicken on my sign. So as a part of that, by the way, was to send the message of what I thought about political signs.
That presumes there's a machine robust enough to actually take a picture of him.
It would break the camera immediately. Other questions, comments, other kind of thoughts about signs and property, and you can't. Well, that's the problem. Is we're going to keep dealing with this issue. You got to turn on your microphone.
Yeah, I'm sorry. Make it simple. Just up to the people that own the property and let us duke it out. I mean, come on. We can do this.
Representative Prunum O'Brien.
Thank you. I don't know. This isn't really a question; it's a comment. But as
we're in comment section. We're in executive session, so you can comment.
As Weiler was Representative
Weiler
was speaking, I was thinking about how I observe signs throughout the community as I'm driving around, during election time. It makes a difference if it's on public property or private property, and I can tell the difference. But maybe I'm looking at it, from too close. Maybe I'm too close to the issue because I see it and I say, oh, those are signs that are on public property. Oh, those are signs that are in someone's actual yard. And it feels like that it's much more of an investment that an individual is making when they put it in their own yard. It means more to me. The other stuff just looks like campaign staff putting signs out. This summer I saw one on Route 89 right on one of the exits. And that was just some campaign staffer who didn't know yet that was not okay. And it was gone soon after that. But I felt like I was a little too close to the issue to really understand it the way maybe the general public does. And if I was Weiler's neighbor, I don't think I would assume that Weiler suddenly started endorsing someone that he otherwise never would have. I wouldn't take that as an endorsement. I would understand that what I was looking at was on public property.
All right, we're at 2:20, so we're going to drop out of executive session. I'm going to leave you with this. Whenever I have a question about how the general public feels about political stuff, I always ask my wife. And the reason being is my wife is very non-political. And she gets politics through osmosis through me being on the phone and it being an important part of my life. But I kind of use her as my litmus test. So there's this corner in Goffstown coming out of Bedford, where 114 turns. And every candidate just throws signs in there and it looks like confetti. And she knows the names, right? She knows because she hears me says things about the candidates. So she knows the names. And we were driving by in September, drove through there, and I turned and said, hey, we drove through that. We were stopped at the stoplight. So we looked at the confetti signs. We stopped where we were there for like a minute and like 90 seconds before we turned. And we turned off and I drove forward and I said, hey, babe, can you tell me any name you just saw on any of those signs? She said, other than the Trump one, no. So that's kind of how it gets to be noise at a certain point is my point. Anyways, all right, we're at 2:20. So we're going to in the executive session. If we have time, we'll come back to that invigorating debate. I did enjoy that. We're going to open up the public hearing on CACR 3 relative to recall elections, providing that the general court may authorize recall elections. Representative Moffitt, do you have written testimony? Is that what that is?
Yes.
All right.
Mr. Chair.
Can you give that
And
to
a
our
vote card.
our wonderful clerk? Thank you. And you are recognized, Representative Moffitt, for the purpose of introduction.
Thank you, Mr. Chair. I notice your operation is very smooth and ahead of schedule. I would point
Thank
out
you.
that in another committee room, we also have two clocks. One is on the slow side, one is on the fast side, which gives the chair some discretion with time. Anyway, for the record, my name is Representative Mike Moffitt, representing Merrimack District 4, beautiful towns of Loudon and Canterbury. So, some students from my original hometown of Groveton recently did a State House visit just last week, and I followed them around for a bit. And even when they visited the legislative chamber adjacent to Reps Hall, and the District 1 senator from Littleton gave a wonderful civics presentation to the youngsters from Groveton. And then he said, are there any questions? And a young girl raised her hand and asked, if we don't like what you're doing, how do we fire you? So the senator was a bit taken aback by the little girl's question. He explained that when the next scheduled election comes up, that the voters could make a change if they wanted. Which brings us to CACR 3. This is a measure we've brought forth before that did not move forward for whatever reason. But sometimes it takes us 2 or even 3 tries to get something moved forward that should move forward, like this. So please note line 12. We're only talking about adding 22 words to our Constitution's Article 5, the General Court article, the legislator article, quote, and to provide a recall procedure to permit citizens to remove an elected official before the end of a term of office, unquote. That's all, 22 words. And it's kind of enabling legislation, if you will. It would empower the legislature to take action in this area that constitutionally really can't do now. So we don't have a prescriptive plan here. That would be down the road if this ever passes and if the legislature in its wisdom thinks that it should look at a recall procedure. So when I brought this forward the last time, a state rep approached me in the lobby and said to me, you know, we have 2-year terms here. I said, oh, thank you. And later another rep approached me and said, you know, all elected officials in New Hampshire serve 2-year terms. To which I responded something to the effect, well, I'll be darned. I know that. I'm the guy who puts a lot of civics measures into play and into law. So I should probably point out, which I just did, that civics is something that I take seriously, and I'm very proud of the stuff that I've gotten through and I'm still trying to get through. So I get it. We have 2-year terms, but this really isn't about us. It's really about municipal and county officials. Back momentarily to legislators, who, as you probably have heard, served 2-year terms. I'll point out that a state rep from our gateway city was elected last term despite some serious legal problems, some of you will recall. In fact, when it came time for our organization day, this rep was incarcerated at the time. The person was in the big house, not the state house. And with our House party breakdown, something like 199 to 199, something like that, there was an acute interest in the status of this rep who was incarcerated. So the point I'm making is that even though this really isn't particularly about 2-year positions, it could be. It could be. And so if my representative was incarcerated, and it happens, there's countless examples all over the country, not so much in New Hampshire, but I might be like the little girl from Groveton and say, what do we do with my rep in jail? But again, this is mostly about 3- and 4-year terms. So many elected municipal board members serve 3-year terms, as you know, select boards, school boards, on and on, 3-year terms. You all are the experts on that. So we even have some county positions now that are 4-year terms. And so that's the nub of this thing. This is to empower the people. What if a municipality, a county, a town, a city, whatever, has some bad actors? What if they get a skunk as a school board member or a select board member or a county official? Someone who lied like crazy to get elected. We've seen it. We've all seen it. And then they do a 180 once they get elected, and they go against what they said they do or promised they do or who they were. And then the voters, the citizens, are stuck with this person for years, 2 years, 3 years, even 4 years. So what can we do? What can we do with these people? Well, can you say paid administrative leave? That's happens all too often. So this is really about empowering citizens and giving them a way to fire, if you will, someone who needs firing. Someone who saw I'd submitted the CACR said to me, good luck with that. You think politicians will ever give people the means to fire them? And I hate being called a politician. I don't think I'm a politician. Politician's some big money dude. I correct them. I say, we're citizen legislators. I'm not a politician. I'm a citizen legislator. And I want to think that all the legislatures in America, truly the world famous 424 member New Hampshire General Court, where we earn $100 a year, is the noblest, least corrupt body in America. I believe that. So I'm not sure why these 22 words haven't been added yet to our Constitution, maybe this time around. So when the Groveton kids were walking out of the legislative chamber adjacent to Reps Hall, okay, it's the Senate. For you watching at home, I'm talking about the Senate.
You can't use profanity in here. I'm sorry, sir.
Okay. I hear, Mr. Chair. So if I saw the little girl as they left that other chamber, and I went up to her and I said to the little girl, I said, that was a great question. I'm glad you asked it. I'm not sure if the senator liked the question, but I did. And I just want you to know that we're working on it. So a CACR is a heavy lift. It has to get through this esteemed committee, then the full House. If it'll go to the House anyway. It has to be voted on. It's a CACR. It needs 60%. And then it needs 67% approval on a statewide ballot, as you know. This committee knows that better than anybody. We just had a CACR on the ballot in November. It got 66+%. It came just short of the 67% that was on the judicial retirement age. But you know what? I believe if our fellow Granite Staters get a chance to vote on this CACR, I think it would pass easily. And that's saying quite a lot. 67% is a high bar. I truly believe if the people had a chance to weigh in and improve the Constitution in this manner, 70, 80%, I believe it. I think the people want this. Our people, the people we represent. So I hope this committee and its collective bipartisan wisdom, this by the way is bipartisan support. It's not a partisan bill. I hope you'll give CACR 3 a chance and eventually give the people a chance. And I'm happy to try to answer any questions if there are any.
Questions from the committee, Representative Wood.
Thank you, Mr. Chairman. Are you aware there is a way now to remove an elected official?
Am I aware that there is a way now to
Remove an elected official?
I know there are some processes in place in certain, you're talking about on the municipal level, correct?
Correct. Anybody elected?
Right.
I believe it's anybody that's elected.
There are actions that can be taken.
So why would we need another action?
Well, Representative, you go ahead and describe the action now. If somebody in Pittsfield was a select, or let's say any town, someone from any town was a corrupt board member who needed to be removed, tell us that process. If
He can't do that. He can't. It's a one-way street.
Okay. Yeah, to answer your question, yes, there are ways to do that now. I think they're cumbersome. I think that they're not easy. I think this would enable the legislature to put the imprimatur of the general court on a process yet to be determined that would apply not only to municipal officials, but also county and state officials. Does that help a little bit?
Thank you.
Yes, Representative C.
Thank you for your question.
Thank you, Mr. Chairman. Thank you, Representative, for taking my question. What about appointed officials such as on local level, my town clerk happens to be appointed, or the deputy clerk, not the actual town clerk is elected. But also like on the state level, the various appointed department heads of all the various state departments.
That is a great question. And you all heard the question, what about appointed officials? So that's the beauty of this proposal, Representative, is that if this enabling language got into the Constitution, then the legislature, then folks, reps or people in this committee could come up with some sort of language to enable municipalities to do something about a appointed official that may or may not be that we may or may not be able to do anything about now. So, great question, and that's another reason I think why this would be good to move forward, so that such actions could be put into law to address that.
Further questions from the committee? Yep, Representative Muirhead.
Thank you, Representative. Would you, if this were put into operation, would you have any concern about extremist groups on the left and the right, very well-funded extremist groups, mounting recall campaigns every time someone was elected where they disagreed with the outcome of the election, so that governors, for instance, would just constantly and routinely face recall campaigns in their first months in office?
Thank you for the question, Representative. That's a great question, honestly. And my answer to that is not that you're trying to scare anybody with that, but I think that notion is the type of notion that would spook people and say, well, you know, extremists could come in and so to avoid that scenario, we should not do this. I will say that in our federal system, it's always useful to see what other states are doing. And many other states, has this been a problem in other states? California, not that I'm saying they should be a model, but California has a recall provision. They recently, just 2 years ago, recalled their governor. How did that happen? They had tens or hundreds of thousands of people sign on to do that. I don't think they were extremists. In fact, in 2003, California did recall Governor Gray Davis because he lied and he did this and did that, and he was not who he promised he'd be. They had a recall election, and Arnold Schwarzenegger, or whatever his name was, became governor. So my answer is that is a good question, and I trust the American people in our processes. And if some small minority of extremists wanted to do what you describe, I think the better angels that I think populate all of our communities would prevail. Hopefully that answers your question somewhat.
Thank you. Representative Gufskovsky.
Do we have that big of a problem in the state where we need this change to the Constitution? Just a little anecdote. In Northwood, we have removed one person from the school board, and a planning board member, the town wanted to remove that person. We had at town meeting, and as a selectman, I'm on the board, we chose not to remove that person. So there are processes in place, and I'm just concerned in making a constitutional amendment just for the sake of making it. Do we actually have a problem that you feel we need this amendment now?
Thank you for the question, Representative. And the representative from Pittsfield already made the great point that there are processes in place, as you described in Northwood, to do this. And as I said earlier, I really see a need to empower the legislature to broaden the power of the people to do more than take on what malfeasance they may see locally. It is another example. There may be some localities where there's a whole cabal of people who are not doing the right thing. So if this legislature someday puts something into law that would enable people locally to petition or have other means of redress to address malfeasance when it occurs, and it does occur. We can all think of examples. So yes, I hear you, and you make a great point, as the representative from Pittsfield did. But I think our existing processes could be better and broadened to include the rare occasions where there might be some county or state officials. I don't see this as a threat to most two-year terms, as I've already mentioned, but that can happen. I gave an example already of one state rep who, had they not resigned, I think the people would have wanted to have the chance to replace that person. And without enabling legislation that would enable you all to come up with some ideas, then that will still be out there. And if we don't do it now, someday, somehow, I believe that will broaden our recall procedures.
Further questions from the committee? Seeing none, thank you.
Thank you, Mr. Chair.
I don't think I have anyone else signed up to speak for CACR3, do I? Nope, I don't. Representative Guzofsky? Yes. It's only taken me. Online, there were 9 in support, 32 opposed. And then on the blue sheet, there was 2 people signed up who didn't speak, both against. With that, we'll close the public hearing on CACR3, and we'll wait 2 minutes to do CACR4. Look at that, right on schedule. All right, it's 2:40. Representative Ulrey, you want to grab a seat here? It's our last bill of the day. We're on schedule. I'm gonna keep saying that because I'm so happy about it. Going to open up the House public hearing on CACR 4 relative to voting eligibility, providing that only legal residents who are at least 18 years of age or older who reside in the place they claim as a domicile should be eligible voters. Representative Ulrey is recognized for the purpose of introduction. Representative Ulrey, welcome to election law.
For the record, my name is Jordan Ullery, Hillsborough 13. That's the town of Hudson. In reading the New Hampshire Constitution, you notice that any inhabitant of a community is entitled to vote. Just an inhabitant. Doesn't have to live here, doesn't have to reside here, just has to declare a community in the town as his inhabitants, and he can vote. We've run into several issues of this. Today, or yesterday actually, if you listen to the news, there were a couple of people from Massachusetts who were charged with the crime of voting in Ashland repeatedly in town elections and in state elections and in federal elections. Now, they may have violated federal law. They may not have violated state law because the Constitution says you only have to be an inhabitant, and they were declaring inhabitants in one town where they actually spent the majority of their time someplace else. We have a lot of people who are, as you know, snowbirds, good time of year for snowbirds, except there's more snow in Florida than there is in southern New Hampshire right now. But the idea is to codify our Constitution to say exactly what it meant when it was first put into existence. That is, that if you're going to be a resident, you need to be a legal resident. You need to be 18 years of age, you need to be a qualified voter, and you need to be a citizen of the United States, and you need to actually reside where you say you do. Put that in the Constitution, it just tightens up the entire legal process. Very short, very sweet, right to the point, just a couple of lines. And I'll be happy to answer any questions.
Other questions from the committee? Representative Wood.
Thank you, Mr. Chairman. I was looking through the bill here, and I noticed you took out inhabitant twice. And further down, every inhabitant of the state, on page 2, line 17, every inhabitant of the state having the proper qualifications. Did you mean to keep it there? And that
more eyes that see it, the more eyes catch things. Thank you, sir. No, that should be corrected.
Okay.
Further questions from the committee? Oh, wow. Okay. All right. Thank you, Representative Ulrey. I thought there'd be some more questions on that. I guess not. All right. Next up is Liz Tantarelli from the League of Women Voters. Ms. Tantarelli, I don't think we've seen you yet this year, so welcome to election law. If we have, my apologies. I just don't remember it, but I don't believe we've seen you this year, have we?
I don't remember either, but
Okay,
thank
fair
you. Thank you, Representative Barry. Things are kind of confusing this year. I just realized I signed in the wrong blue sheet. So anyway, here I am. You've got my card. So thank you for this opportunity to speak. I'm Liz Tantarelli. I live in Manchester. I'm president of the League of Women Voters. We're a nonpartisan organization, and one of our self-imposed obligations is that when a constitutional amendment comes up, we try to explain it to voters. And unfortunately, the way our ballots are set up, nobody quite knows what the change is. And it's a real challenge for voters to understand what they're voting for. In this case, I'm opposing the bill itself because of the term legal resident, because I think most people don't know what that means. For instance, is a homeless person a legal resident? We know that they are allowed to vote and they can use their social service agency as an address to vote. We know that somebody who's incarcerated in a house of corrections is allowed to vote.
either while awaiting trial or while serving a misdemeanor sentence. Are they a legal resident? It's just a weird phrase. What about the young person who is a roommate and has no name on a lease? Somebody else has the lease. He's a roommate. My grandson was in that position for a couple of years. Is he a legal resident? So I think when you start putting in words that the average voter is going to scratch one's head about and just not know what it means, that doesn't help anything. This amendment, the wording that already exists clearly says you need to be domiciled. You're there. You have to be a citizen. You have to be 18. We know this already. And so I think all this does is create confusion. And I think I don't particularly want to take questions on this, but thank you for the opportunity to speak.
You are the first one this year not to take questions, and I love that. I love that there's take better. It's awesome. All right, next up is here we go. All right, Kaylee E. Everybody, Kaylee E. Kaylee E.
Members of the committee, my name is Kaylee Evstradio. I'm a Durham voter and public policy fellow with Open Democracy. And again, I am testifying on behalf of Bob Perry, a former member of this committee and a board member on Open Democracy. So he says, I write in opposition to CACR 4. The CACR makes major changes of consequence for voting under the New Hampshire Constitution as it currently exists. The proposed amendment removes references to inhabitants dating back to the original language in 1784, defining inhabitant as a person who has a domicile. I suggest the founders recognized the mobile nature of settlers, so chose not to confine them to a standard of permanency by way of residency, such that any definition of residency could account for the movements of the early settlers in search of safety, home, or job, any more than the movements of modern persons. There is no definition of, quote, legal resident or its derivatives in the amendment. Therefore, the intent of the amendment would be subject to a definition determined by the legislature after the amendment were to become law, thus adding ambiguity, potential surprise, or remorse. There is a definition of resident and its derivatives in the motor vehicle statute at RSA 21, but such statute does and should not bear a connection between the privilege of driving a motor vehicle and the fundamental right to vote in this state at Part 1st, Article 11 of the New Hampshire Constitution. Existing state statutes of long standing under RSA 654 set out requirements for voting that a person must be a citizen of the U.S., and the requisite forms for voting amply set out those requirements, with penalties for wrongful voting included in the forms. The language, quote, and actually reside in the place they claim as domicile, is problematic. The word reside, a derivative of the word resident, conflicts with the rights of students, for example, who may claim their place of higher learning as their domicile, under RSA 654(1) for purposes of voting. The amendment would also be problematic to overseas voters under RSA 654(3), Uniformed Overseas Citizens Absentee Voting Act, who may claim a U.S. domicile even while temporarily stationed overseas, whether short or long term, who obviously do not actually reside in the place they claim as domicile. Adoption of this amendment, therefore, would require the repeal of multiple statutes to include RSA 654(1), voter office holder, RSA 654(2), temporary absence or presence, RSA 654(2)A, voters confined in penal institutions, RSA 654(3), Uniformed and Overseas Citizens Absentee Voting Act, RSA 654(7), voter registration form, and a potential for other appeals not noticed here. I urge ITL. And me speaking as myself, I also just wanted to add that, as I mentioned previously, I am a Durham voter and grad student at UNH. Although I am from Massachusetts, I do actually reside in the place I claim as domicile for 10 out of the 12 months of the year, probably more. I spend way more of my time in New Hampshire, and its laws affect me way more than Massachusetts do, and it makes more sense for me to vote there. I also plan to move here post-graduation, and countless others like me are in the same situation. So I am worried that the language actually leaves too much room for interpretation. Thank you.
Will you be taking questions?
Sure.
All right. Are there questions from the committee? Seeing none, thank you. Last up, we have Olivia Zink with Open Democracy. Representative Gosowski, can you grab the blue sheet?
Good afternoon. I think I'm standing between you and leaving, so I'll be quick.
It's a dangerous place. The only worst place to be is lunch. That's like, whoa.
I'm Olivia Zink, Executive Director of Open Democracy, and I live in Franklin, New Hampshire, and I'm here opposing this bill. Currently, the Constitution guarantees the freedom of all inhabitants that are 18 years older and citizens, the ability to vote in New Hampshire. And I think it's important that we make sure that we're not unintentionally harming any voter. As mentioned before, it could be somebody homeless. It could be somebody that's recently divorced and staying on a friend's couch. There are many different reasons where somebody may not have a legal resident. I was just wondering, what is a legal resident in New Hampshire? So I looked. Elderly voters are residents of nursing homes under RSA 151. And we know that elderly voters can vote from their nursing home or from their previous home. We allow them that choice in our election laws. So we'd have to change those statutes if we make them a legal resident, and no longer elderly voters would have that choice. And then what is legal residence when you are purchasing a house or leasing an apartment? Those are different RSAs around residency. And there's the motor vehicle residency statute. There is placing dependent children in publicly funded schools statute. And then there is a whole host of statutes about what is your residency under Health and Human Services. I've cited all of these different statutes of what is residency because I think it's important for us to know which one of these residency standards would be what we would be defining to vote for folks to vote under this proposed amendment. I urge the committee to support everybody's freedom to vote and vote ITL on this constitutional amendment. With that, thank you, and I won't take questions.
Oh, yes. All right. Double up. No questions today. All right. We have no one else, no other pink cards in my possession. There was one person on the blue sheet signed up against who did not speak. Online, there was 110 in support and 95 opposed, which is why I thought this one would go a lot longer. So my apologies. I probably would have put in 2 more bills if I knew we were going to fly through this one. We're done for the day. I'm close to public hearing for CACR 4. Some quick announcements. Yes, we are meeting next Tuesday. Yes, every bill we heard today, so that the cadence will be, the bills we hear on Tuesday will be by default noticed for the next Tuesday. So that'll be kind of the cadence. So if there's a bill that needs work, right, you need to let me know. It's not a big deal. I just need to know. But that's going to be the cadence. I'm going to take the 11 bills that we heard today, and they're going to be noticed for exec at the end of the day for next week. And I know Representative Muirhead is trying so hard not to hear my voice anymore, but I do need to speak with you and the Vice Chairman about scheduling for bill hearings next week. I'd like your consultation on it. So with that, I will see you guys next Tuesday at 10 a.m. for hearings and executive sessions. So Deputy Ranking Member and Vice Chairman, please make sure your substitutes are in place. And yes, we'll meet in 308, Representative Muirhead. Thank you guys. See you next week.